Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughed him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict's live stream in their courtroom.
The fireworks are not done.
We're getting commentary on the case. Dahil mihi Anglican for his service left.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, for Trump's sake.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here this morning. Hope everyone is doing just dandy. Dandy's an official status update, by the way. You can. I think they should have it on Facebook. It's like, I'm good, I'm well, it's complicated, I'm dandy. Just dandy. I'm dandy today. All right, welcome. I think everything's working. Camera's working. Counter's going to be working shortly. Let's see. Going there in just a moment. Come on, Friday, says Mindy FS. Big shout out to who? Somebody needs a. Let's hope your sick house is dandy here. All is dandy. I'm looking extra dandy today. Why, thank you. I don't know who won the internet. I apologize. I should have peeked. Let me see. Fran Fitzgerald. Fran, hang on, just 1 second. Let me make sure it's you. Live chat. And yes, Fran, first and second place, nearly first, second, and third. So we're going to go ahead and recognize you. Fran, congratulations. Your promptness has earned you a punishment. Everything IP related worldwide is your responsibility. You are, in fact, the internet owner for the day. This goes on your permanent record. There we go. All right. Welcome. It's should be finishing off the case today. But there's one thing about today that you probably ought to know. And that is this.
Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! Welcome to Wednesday. I count 5.5 thumbs up from the Peanut Gallery. Daughter may be up for adoption. She's the one that gave me the half. Welcome. It's halfway through the... Oh, I have a sleep. I'm sorry. Greeners, I'm sorry. Although I do appreciate you putting a monitor, like literally a TV monitor right next to the baby so I can speak directly to it and subliminal messages while it sleeps. That was quite kind of you and quite trusting as well. Fran says, I'm gifting the internet to Northwest. Well, we checked the rules, Fran, and apparently you are able to re-gift the internet one time each day. So Northwest, this could be good or bad news for you. You are now... Oh, let me put it on screen, make it official. You are now the internet owner. Everything IP related worldwide is your responsibility. You are treated as if you were first in chat. As a matter of fact, for legal purposes, you are first in chat. And everything that follows is your responsibility. Congratulations, Northwest. This goes on your permanent record. You can now order your certificate now. It is suitable for framing or use as a cover sheet on your CV. So it's wonderful. Congratulations on that one, Fran. Very generous of you to give that responsibility away like you did today. Wonderful. Let's do birthdays. Shall we do birthdays? I just barely put it on screen. I hadn't for a little while, but I just caught it myself. Started up the help desk engine. Yeah, get those phone lines ready. Internet's been pretty bad recently. I hope you're prepared, Northwest. Just letting you know. Just heads up. All right. Do we have any birthdays today to celebrate? If not, that's fine. That's fine. Oh, Sandy. Is it Tarjay's birthday? or Target? Are we singing to a box store?
In front of the
A
Walmart.
big box store. I need to know. That's not Walmart. Pink Magnolias, it's my birthday. We're going to add you to the list as well. Okay, we're going to sing to Sandy, Target, and Pink Magnolias. As long as we have a real person in there somewhere, I think it's official. So, Sandy, obviously, real person as well. We'll sing to Sandy, Target. Seems weird that we're singing to Target. I just don't recognize the name. Unless I'm out shopping. And Pink Magnolias. So everyone, wherever you are, if it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. There we go. We found our notes. Happy birthday to you. Happy birthday to you. Happy birthday, dear Sandy, Target, and Pink Magnolias. Happy birthday to you. I hope it's... Was it the store? Did we just sing to the store? Either way. Maybe they'll give us better deals from now on. Sandy, Target, and Pink Magnolias, there are many, many wonderful days. Many, but today is your special day. I realize there are a million places could be and a billion people you could have celebrated with, but you chose to be right here with us. The privilege, pleasure, the honor, the joy, that's ours. Hopefully we can turn that joy back to you and make your day just a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlop's House, Andy's Grill, Bob Evans' Cracker Barrel, and St. Peter's Grill. Heavenly birthdays get pancakes too. So, happy birthday, happy birthday. High kicks, go. Make it snap. Make it snap. 2, 1, 2, 3. 1, 2, 1, 2, 3. And kick, and kick, and kick, and kick. Now jazz hands. There we go. Perfect. You guys nailed it. Nailed it. That practice did pay off. Congratulations. I appreciate the good words about the hump day yell. I gave it my all that I had today. I gave it. I've had better other days, but that's all I had today. Did we notice the face tats on the defendant? Oh my goodness, he's got some good dudes. He's got a spider web in his hair, like a tattooed spider web. I've never seen that before. And then he's got the diamond right on the in the hook spot. I don't know what do you call that? Right on the below the corner of your mouth. That's the hook spot if you're fishing, right? Yeah. Anyway, drum solo for the big finish. Here we go. Beautiful, beautiful. Good job. And as always, dancers, you need more practice. Not that you didn't do well.
Happy birthday.
But the new routine, it's got some new moves and stuff in it. We're going back to court with Judge Stevens as we are continuing our coverage of Mr. Trevontae Nichols and his triple threat charge of aggravated assault, where he's accused of shooting into a vehicle with 3 occupants inside after a encounter of some sort that did not include beef, according to the testimony, in the Last Call liquor store. Started at the liquor store, ended at a Walmart. At least that's when they caught up to the victim and took their statement. So we're going to go ahead and pick up where we left off. Oops, not that one. This one. Judge, you ready? I think you're ready, Judge. How are you doing, by the way, Your Honor? Appreciate you being here every morning.
In front of the Walmart.
Bright and early. Northwest, thanks for this info. Okay. Northwest, you're a gold mine of information, by the way. Victim Philip Bennett is in Jefferson County Jail on 2 deadly conduct discharge of a firearm charges. I wonder if they had to do with him shooting back. Honestly, do you think it was the same event, or was it some other shooting he randomly got involved in Probably also didn't include beef. A little bit of docket work here with the judge before we kick off court. Wow. I like the look. You've got the hair and the tie and the shirt. It completes the ensemble. Although I do think the glasses need a red. Do they have a red band on them? They might have a red band
the
by the
defendant is
temple.
present with Mr. Lane and the state. It's an announcement. What are we doing today?
Your Honor, we're just waiting on videos. If I can have 30 more days for an announcement.
I was indicted last year.
Judge, I'd like to point out I made a offer in writing to Mr. Lane back on June 23rd of this year. The videos, of course, have been available at least since that period of time.
Why? Hadn't he got to it?
I've requested it and I asked if they were available yesterday and they said they're not done yet.
Judge, I'll point out that no one has
here.
Exactly. I'll point out that no one has made me aware of the fact that he's not been given up or provided.
Who did you talk to?
I think I'm talking Renee. Renee.
As the prosecutor in the case, I'm always happy to help facilitate those kind of issues if they just let me know, Judge.
I'm not blaming the state, Your Honor.
I got 2 weeks, okay?
Thank you, Judge.
Thanks. Okay.
What?
Hey, Reagan.
Yes, sir.
On Antikar Raman Khan, is that right?
Jimmy and I are still working through some things on this, and I need to.
Where is that person?
No, I can help you.
Yeah, there's right now, Jimmy's written down no offer on it because there's some other stuff he's looking at. So just looking.
Okay, today, then what are you asking to do? You got it? Thank you. Stephanie, Caleb Ledger or Lejeune, whatever the case may be, it looks like 2 cases. 2 cases, right?
Yes,
Lejeune, Ledger. I really saw that same day.
Yes, Judge.
2 people.
Yes, Judge.
Ag assault, 2 victims. Wow, people dressed to the nines for this court. This is awesome. I love the respect. Judge Boyd would be happy.
Been there, done that on both sides. What? Because I have those.
I'm wondering. Yeah, people still have solid my relationship with her. I was thinking about that last night.
I'm gonna have a solid relationship.
Well,
He tried to trying to feed you this detail. It'll speak to you, that's true. But you can't have a good relationship.
okay. I'm just trying to think. It's gonna be a good one.
Just buy your motion to do that.
It's a very chatty courtroom. Judge allows it.
Once you get that shit, then there's other offer, you go and take over.
Breaks out his highlighter. Makes a few notations.
They'll pump people stuff and make you memorize a few things. And this is the court, this is the judge, this is what the lawyer does. If I go back to the different topic.
Do you think this prosecutor thinks he's all that?
I'm sending you back before he changes his mind.
This prosecutor is, I think he has a high opinion of himself.
It is sad. That's sad.
They are related. Northwest, you are a regular document sleuth. We might need to. I mean, you're doing all this while you're taking care of the internet for the world, and you're still pulling this stuff up. Defense cases. So police didn't believe that he was firing in self-defense then. He jumps out and shoots back. Emptied a clip on him.
And we've been on a year of this, the anniversary of this incident. So what is today is announcement.
He wants to finish his song job.
Yes, there is no deal on this one. I looked
Yes,
at
sir.
it.
I understand.
We tried this.
I'm familiar with the underlying facts. I understand perfectly.
Let me know if anybody's trying to get in contact with the victims. I'd like to know that
Yes,
so
sir.
that the court can administer some.
Reagan went ahead and put that.
Understood. Thank you, Judge.
I needed the file. I just wanted you to see.
Okay.
My question
We're going
is,
to trial.
is the defendant in this
And,
trial
there are
a
no
victim in
deals
the other
on
one?
this. We're going to let a jury decide what this conduct is, and I've read it. And it's a most disturbing probable cause affidavit. Get a resetting. Put this to trial as soon as possible.
Yeah.
Thank you. Next is,
Wonder what that one was about.
a note on that. There is no deal,
Yes,
so
sir.
I don't forget.
No deal.
Joseph Williams.
Denied.
Joe.
We gave
One
my
case, yes, Judge.
we give my son a little drone, and
Well,
he's flying
we'll
around the
look at
house like crazy. Little airplane. Okay, sir. You saw everyone else was dressed really well. Then you showed up in Levi's and your work shirt.
Okay, short for a minute.
Joseph Williams.
He looks at the shirt, tries to make sense of it. The defendant looks down at his shirt.
I shouldn't be like a parent here. Would you wear that to church?
Yes.
You would wear that to church? You don't have any other clothing?
Those are dirty.
What, have you heard of washing clothes?
I couldn't.
That's a regular.
Sir.
Why couldn't you?
Because I had a time to, and the washer is mixed up in my house.
Okay. All right. Well,
My apologies, sir.
so you wait until all your clothes are dirty until you go and wash them?
No,
I
sir.
mean, you don't have any backup plans?
No, sir.
Because
Did not do that.
that's not appropriate. Look, just look over. Look, just look over. Look over. No, look over there. All the men are with ties. You notice? But it's something, and the ladies are all dressed up nicely. It's because this is an honorable place. This is what the Constitution, this is what the flag stands for, what goes on in this room. It's the Constitution. Respect, it's respect. And the way you're dressing, it shows little or no respect. Look, I grew up too on the planet. And I was single, and I had to take care of my clothes, and I never ran out of all my clothes before I decided to wash them all again. I mean, that's being prepared. Don't dress like that again in here, okay? Just show respect for all of this. And you're charged with a second-degree felony of burglary of a habitation, which carries with it up to 20 years in prison.
You could have
20
stole
years in
some
prison.
clothes.
I would find that disturbingly sober and serious if it were me charged with this. All right, but you gotta act like it's important to you.
Yes, sir.
All right, Ms. Minaldi is here.
What does that
and
shirt
it's an
say?
announcement.
Now
What
I
are we
need to
doing?
know.
Trial?
No,
On
Judge,
this
if I
one?
could have 4 weeks, I just received the offer from Jimmy, from Jimmy's file from Mike this morning. I
And
need,
it's 8 months old. No,
The offer is?
this is,
I know it was handed up on January 21st. It's getting on.
all of
it's
us,
getting toward 8
all of us are
months.
like, I need to start the laundry.
I mean, the decision has to be made.
Where we
You have 2 weeks. I give you 2 weeks.
okay, Judge.
Thank you.
Said.
Kimberly Free. So that's Mr. Carr, is that you? George motion.
What, Judge?
Hey. Hey, did I miss Daryl Lewis?
I just gave some time. I forgot to write in.
Oh.
Yesterday.
Because I couldn't find that on the docket. Oh, Kimberly Free. And this one, you were charged with a second-degree felony, assault. Looks like on a peace officer. Well, this carries with it up to 20 years in prison. of course, it's a serious thing. And this is announcement. What are we doing today?
Judge, I'm working through the discovery on Mrs. Free's case, so if we can get one more resetting so I can work through that. I think there may be some legal issues with this as well.
Yeah, 3 weeks, okay. But you say there are some legal issues?
Yes, sir.
There's legal issues in every case.
I'm not trying to.
That's why we went to law school, because we don't do medicine here. It's all legal.
Well, I don't know. Sometimes there are some strange things.
What would get my attention if you said, no, I'm doing an appendectomy today and I don't have time to give you this trial. That would get my attention.
I'll toss up the tonsillectomy later, but
hey, I had one of those.
I stayed as a holiday and select last night, so.
But you know how to do it.
I know.
You're ready.
I stayed at a holiday.
You're welcome.
George Moten.
You're interested, or you're
not a sponsor.
I'll be here all day.
Well, you heard the crowd response.
I know. I'm a lawyer, George, not a comedian.
You're telling us?
Oh man, look at this. Look at this. Love it.
What's it here?
Mr. Moten?
Yeah.
Well, there's some medical records that I think the defense has that wants to talk
This
to
guy just
Tanisha
needs a
about,
boutonniere
but
and
they
he's
haven't been able
ready to go to a dance.
And she's at that seminar this week, so.
This was an announcement.
Yes, sir.
Again, that, it's like one indictment was handed up in February and the other was in March. Injury to a child, which is a state jail felony. And then the continuous violence against family. That one's a new one. I don't think I've seen this one.
It's pretty new
lately.
Type of offense, too.
And this is a 3rd-degree felony. So between a state jail felony and a 3rd-degree felony, you're looking up to 12 years in confinement. Serious. And they're both felony offenses. You need how much time?
Just a normal reset, Judge, in 4 weeks.
No, there isn't anything. I'm going to give you 4.
That's fine.
Okay. Justin Patterson.
Hey, sound like a broken record, Judge, when I'm working through the videos on this one. This is where he's indicted for threatening to assault and murder a police officer. I've yet to find part of the video where it says murder. I'm trying to work through the videos. There's quite a few on his case, so I think we can get another reset so I can continue to work with the videos on his case.
Okay, you or Justin Patterson?
Yes, sir.
Okay, you're charged with this 3rd-degree felony of obstruction or retaliation, but that's not the end of it. You've got 2 prior felony convictions, assault on a peace officer, which...
He doesn't like cops.
I can't imagine that that's going to play out well in a trial with that, if that comes out during a trial, and then evading detention all in 21. So if you're convicted of this 3rd-degree felony, and if these prior convictions were proven true, you're dealing with a 2nd-degree felony, up to 20 years in prison, and you're not eligible for probation in front of you. So there's a lot of things to think about. Well, how much time for a decision? 4 weeks?
Yes, sir.
Okay. And Jean-Claude Butler? Okay.
Jean-Claude Van Damme. Butler, never mind.
Good.
I have never seen so many defendants so consistently well dressed as in this, courtroom.
Look, on these things that are motions for examination on insanity, I'd like those. Yeah.
Judge, this is, we're trying to renew the plea. This is one that from Monday that the family's wanting to go through with this plea agreement on both sides.
If the court recalls, you indicated Monday we would set a hearing for today. I presume with regard to the introduction of evidence to support an insanity defense.
I can't remember since
it's generally pretty serious.
We disposed of 3,000 cases last year.
Charge if it's an
These
insanity defense.
This is a typical day. We're set for trial. Well, so
No, sir,
there's a motion for examination regarding insanity. What do we do about that motion?
They were willing to waive that and plead
Is that what they're doing?
probation on Monday. I don't know if they're still willing to do that or not. I thought that's what the plan was today.
I mean, it
To do
really
the first-
depends on the court. And
What does it depend on the court on?
well, Judge, we were in the process of entering the plea on Monday when the court shut it down and said that the court was going to put it back on the trial docket. So if we're going to do that, then we need to pursue that motion rather than waive it.
Well, obviously, what had been presented before me, what information I had, obviously caused me some concern to stop and back up and be deliberate on
Yes, sir.
this.
But speaking, this is something that the family is wanting you to follow, both sides, to make sure he gets some help. And I think this is the best plan to do that in the interest of justice for all
So
involved.
what would the plan be?
Be deferred and place him on the mental health caseload to make sure that he's taking his medications and doing what he's supposed to do for a couple
Are
of years.
the families here?
They're not here, Judge. They're watching on YouTube, but they've been calling. I mean, they've been calling your clerk also. So
How are they, are the families related?
yes,
Okay, this is an intra-family
Yes.
situation between complainant and victims.
yes, they're all part of one big family.
All right.
So the paperwork, we still got the paperwork from Monday. I think we can still use it.
That's what y'all want to do. Let's
Yes,
move
sir.
forward.
Okay.
Is it on the, still on the pad?
Yes, sir. It should be for Monday.
Who it is?
Who dis? Clip-on ties. Renting clip-on ties and one size fits most shirts outside a courtroom. Great business model.
You want me to switch them?
It's almost, you could probably run it like a food truck.
I logged in the
Partner-
wrong one.
partner with a laundromat down the road.
That's ours.
Give everything
This is working.
a quick wash after use.
To use. That's okay. I don't need one. It's fine.
Well, hey, this thing is really hot.
Yeah, they're warm.
Do they
It's fine.
sell them for this one? Okay, we call then 25 CR 34, the state of Texas versus Jean-Claude Butler. That's you? You have to speak out, so this lady, thank you. And you hear Mr. Wilkerson is your attorney and the state's prosecutors here.
This is a serious one, I think.
You understand you're charged with a third-degree felony of injury to elderly persons, right?
Correct, Judge.
Okay. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, Your Honor.
In summary, this indictment states that on or about November 2nd of 2024 in Jefferson County, Texas, you committed the third-degree felony intentionally and knowingly causing bodily injury to Sowillo Richard Petrie, an individual 65 years of age or older.
You fought with Grandpa.
By striking that victim in the face with your hand. Do you understand what you were charged with, sir?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000.
Yeah, they're living separate.
Yes, sir.
An agreement has been reached where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length. If you do well, I can shorten it to 1/3, which is 3 1/3 years. I see there's a non-binding recommendation, but the court's inclination is to place you on 10 years deferred or unadjudicated probation, shorten it to 3 1/3 if you do well, which would be sooner than 5 years.
Yes.
Is this your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Let me ask you there was one other thing y'all had mentioned. Y'all had, I thought the parties had some agreed terms of medical or mental or.
We want to place him on the mental health caseload.
right, everybody?
Yeah, sure.
The defendant would be placed on the mental health caseload, which means that the probation office would help you on
might skip
issues
ahead a little
that
bit.
you need to address, maybe for anger management or something like that, that will help your decision making so that you don't violate your probation.
Okay.
Yes, sir.
Hold, please. We're going to skip ahead just a tiny bit. They're still dealing with this guy. Still there.
Listen.
There we go.
Okay, I've got Daryl Lewis.
He was going to come in this morning and fill out the indigent paperwork for me.
Me too.
Where is
Graders. Me
He's
too.
moving.
Well, I mean, he was ordered to do that, wasn't he?
I talked with the bonding company yesterday and they should have been here. He was at Baptist Hospital. He actually was moved from misdemeanor court from the hospital yesterday. My thought is he wasn't discharged, but I'll check with the bonding company.
Okay.
And just need the paperwork. Right.
I don't have any authority if really to enforce anything if there's not an order. And okay. All right. Let's get ready to rumble in the trial here. Okay, everybody. Get prepared. And we'll be getting ready for trial in a few minutes. Thank you.
We'll fast forward through that. Let's get ready to rumble, says the judge. Watch a little, little boxing in his off time. Let's do this one here. Are they ready? Not quite yet. Waiting for the jury. Skipped ahead just a couple minutes. Now we're caught up to live. All right. Rumble in the trial. I'd only just got my red velour tracksuit out. Vanasheen, you've got to be with us tomorrow for the podcast. We have a story for you. Yeah, we've got a story just along these lines for you in the podcast. I'm going to try to get Thomas to read it so I don't blush through it. What's the court sell advertising space on their paper camera covers? No, this is actually case law. These are like jury instructions, old copies or new copies that they use to cover up the camera when the jury walks in or out. When somebody's here to put the paper in place, other times we just see the jury. So definitely a missed opportunity for sure. Bail bondsman might want to hit up the court. It's like, I don't know. You don't even have to make it official. Just slip the judge a 20 and drop off a stack of folded papers that can neatly be kept over by the camera, and you're in business. Just make sure the camera shows the number correctly. And I don't know who else needs to advertise in a courtroom. Aside from bail bondsmen and lawyers, what businesses out there? And I'm sort of asking for a selfish reason because these are possible businesses that could sponsor the channel as well. Could sponsor a trial. YouTube law streamers. This. Runkle of the Bailey sponsors this trial. You can catch Runkle of the Bailey on YouTube. Yeah, that'd be something. I could see a conflict there a little bit, but not a major one. Probably as long as you disclose it, you're good. Any other businesses? Water bottles. Deer Park, not a sponsor. Legal pads and pens. Yeah, this trial sponsored by Bic. Could have like a Flick Your Bic advertisement. Tux Rental and Cleaning Companies. Visa services to Vietnam. Oh, my goodness. I know of one family that might take you up on that offer. You see conflict, I see potential. Crime scene cleanup. And you could use this. Have you guys heard of the spray deodorant for bathrooms? I'm not talking about just like Febreze. I'm talking about Poopery is what it's called. It's called Poopery, and you spray it in the toilet. And their slogan is the smartest slogan ever, but it would probably work for crime scene cleanup as well. Their slogan is Our business is to make it look like your business never even happened. And that would work for, for all sorts of crime cleanup. Oh, rapid urine tests, at-home breathalyzers, reading glasses. Walmart's always a good one. 44. That's a great one. Clorox. Isn't Runkle Canadian? Yes, but we've adopted him. Ad for Resonator. No. Let's see. You have an affiliate link for that you've shared before. Oh, the Poopery. I shared. Is it on Amazon? I shared that one. It's a great product. Kombucha for lawyers. Works in Utah. We have Fabaloo spray into toilet before pooping. No spell. Yeah, it's a knockoff. Fabaloo is a Poopery imitator. It's like potpourri, but Poopery. Yes, you get my 2 cents every month from my Amazon Poopery subscription. Works, doesn't it? GG Sharebear, member for 34 months is Mike. What day is it? 34 months makes you an OG. Thank you very much, GG. Appreciate you being here. I have Poopery in every bathroom. You missed your affiliate link during the Pickles trial. Oh, I should have. Tarps. What about like body bags, like at-home body bag kit? You don't have to wait for the coroner. You can take care of this yourself. There's a news story about that I was reading just overnight as well. It was actually early in the morning. There was some story about it was in Alaska, like around Anchorage, Alaska. There was they're doing a suspicious death investigation because they found a body in a freezer. And I'm like, hey, it happens. Sometimes you go in to get something out of the walk-in freezer and it takes too long and you get cold and you're chilly and you can't open the door and you die. It's terrible, right? It scared me to death when I worked at fast food going into the walk-in freezer for the very reason. What if somebody locks me in? Because it does lock on the outside and you can't get out. So I was always scared. I'd always prop the door open. But in this case, the coroner, the medical examiner, is having a difficult time pinning down the time of death in the freezer incident because they know it's between 4 and 10 years ago. I guess based on freezer burn or something. I don't know. But the evidence was well preserved. But 4 to 10 years is a wide period for asserting, you don't generally see in an affidavit, we believe that you committed murder between 4 and 10 years ago. And it might not have even been murder. It could have just been, hey, it's wintertime. Uncle Fester, whoever, not Uncle Fester because he's like from a movie, TV show, but Uncle George passed away. It's frozen ground. We can't bury him yet. We're just going to keep him on ice for a bit until the ground thaws a bit because we're in Alaska, right? And we know that he was put in there and not accident because it was wrapped in a tarp. It was wrapped in plastic. But the tough part is they found it when they were cleaning out the property for an estate sale because the homeowner had passed away some months before. And so while they're cleaning everything out, they find the body in the freezer. They're like, uh-oh. No wonder nobody had seen him in 10 years. And I mean, that's what they did. They're like, does anyone remember seeing George in the last 10 years? No, I can't recall. So it's one of those cases. So it might be a murder trial. Might just be like, hey, it was, an item of convenience. One of those Rubbermaid outdoor storage boxes is submerged in our lake by our dock, likely blown in during the storm, but we've been afraid to drag it out and open it. What if? You can always call the police and tell them you think it's suspicious. Then make them do it, but then they might not like you. The bank vault always did that to me when I worked at banks. They have emergency air holds built in if you get locked in. You need the air holes. Could be riches. Could be gold. Could be somebody's collection of silver bars, because silver's really gone up in price lately. What is the price of silver? Does anyone know? Let me check with Siri. What is today's spot price of silver?
Silver is up $2.29 today, or 3.8% to $62.54.
I remember when it was $18 an ounce. Now it's 62. It's a good increase. Silver's been a good bet. Not financial advice, by the way. Every court needs IT support. Yes. This would be a good one. IT support. Although the IT support could teach you how to turn cameras on and off remotely, and then you wouldn't need the paper. Lena H., member for 34 months, enjoyed all 34 of them. Oh, gee. Lena, thank you very much. I'm glad you at least say that you enjoyed all the months. Just Stephanie W., member for 29 months, says, love being here daily. You guys always make my day. Thanks for that. Stephanie, thank you. Appreciate it. Wouldn't be the same without you here. Glad to be part of your day. It's probably just cushions and deck chairs, fishing tackle, maybe some life jackets. Yeah, it's somebody's dock storage box. And unless it's wrapped in duct tape, let me put that caveat there. If that little bin, Red, that you found in the water is wrapped in duct tape, both directions, horizontal and vertical, like a package, right? Like an X across the middle, then don't open it, because then you've got remains of something. Yeah. Send a picture, but don't open it. Are you saying this is a good time to sell silver? I think it's still going to go up. Personally, this is not financial advice. Trust me, I'm not going to. Don't use my advice to ever make a financial decision unless it's something sound like pay off your debts, snowball. Start with the smallest one first. Add that bill to the next one once you've paid off your. If you owe $100, you pay $1 a month on that. Pay off the $100 one, and then take that dollar that you were paying off, and add it to your next biggest bill, and roll and roll and roll, and then pretty soon you'll be out of debt. It's wonderful. Not giving advice. No, I'm not a financial advisor. Although I'm a big fan of not being in debt. The freedom, and I realize it takes a couple things to not be in debt, and one of them is luck, or divine providence. The reason I say that is because there are many people that I know that do everything right financially, that to not be in debt is not an option for them, whether it be medical complications and just the cost of surviving from one day to the next with medical issues that they did not choose or control, or something of the matter that similar. But if you do have the ability to pay off debt, it's a very freeing feeling. Let's see. Vanishing about 4 years from being debt free. That's awesome. Not being in debt is financial advice. But really, it's just, I agree with an existing contract. Pay off your contracts. Pay off your debts. That's all. Judge, are we getting closer to court? Living below your means and drive it till the wheels fall off. Which is different from drive it like it's stolen, by the way. But my wife and I made that decision that we would never buy a new car. We bought a almost new car, used, and it was our worst financial purchase decision we've ever made. It was terrible. It was new enough that once we bought it, we were upside down on the loan in a big way. And it sucked because we hated the car, and then we found out that it had special sized tires, and because it was all-wheel drive, every single tire had to be changed anytime one got a hole in it, or flat tire. And it just became like an albatross about our necks. And luckily we found some guy out of Wyoming who collected this exact model of car, which was the Ford Freestyle the first year the Freestyle was out. It's a very blocky sort of SUV-ish crossover. But he has a whole collection of them, and he was more than happy to pay exactly what we owed on the car to take it off our hands. And that was a good day. Have a budget for everything, including YouTube jewels. Yes. Budgets are fantastic. Mrs. R.A. can swear to those. She honestly, every single month, she budgets, and there's a portion that goes to, this is going towards Christmas presents, and this is going towards the annual property tax for both our properties, the little tiny lawnmower width strip and the regular one our house sits on. She budgets for everything. I got this advice when I was 20 years old, and I wish I'd followed it. Because it multiplies fast if you put it in early, and now basically everything I put in I might get 10% on. It's just... Plus, YouTube doesn't have a 401k, so there's that. Is there a cable budget? Yes, I do have a cable budget. Best time to invest is yesterday. Next best time is today. Thank you. I was trying to showcase my latest painting, but the photog didn't get the painting in frame. No! You had one job. Red Pen gifted 10 memberships. Red, thank you so much. That's awesome. Congratulations to the wonderful recipients, all of you good people. I think the judge is ready for court. We're ready for him to at least turn on the mics. He's still doing paperwork. In honor of Red Pen's Modiversary. Just realized it's 1 year Modiversary today. Congratulations, Red. Time flies when you're having fun. Troy, thanks for the golden poop. Appreciate that. Happy poop, sorry. It's been a busy year. It has. It's going to be busier going forward. We're excited to be done with a lot of the court hopping we've been doing for the last couple of weeks.
Finishing up the
next 2
jury
weeks
instructions, and we're going to get back here into this trial while the jury instructions are being performed. Are the parties ready to move forward?
State's ready, Judge.
All right, we need the defendant. They come in handy in a trial. I've always thought.
It's always good to have a defendant.
And
unless you want to try them in absentia. Which is a thing. You can be tried in absentia. But then you have to be like burned at the stake in effigy. It gets tricky with punishment. Look what the storm blew in. Josh says, I don't know when I became a mod, but I became a mod during a hurricane. Still don't know how I feel about that. Was it Helene? Was it during Helene?
And cause numbers 24 CR 300, 301, 302, or all three called. The state of Texas versus Trevontae Nichols. The defendant is present with his attorney and the state's attorney. Is there anything to bring up before we bring the jury in?
Not from the state.
Defense.
No.
Let's move forward and bring the jury in. Thank you.
Thank you. The problem is we pay off our debts, and then something catastrophic happens. $5,000 for a cat bill. Oh, wow. Don't regret it because we've got 2 more weeks before we had them. Oh, man. Abby, you're a wonderful pet owner. That is amazing. That's wonderful. But yeah, it can sure put a pinch on the wallet for sure. Do we find out the love story triangle today? I don't know if that's today. If we find that out, I think.
Wow, look at that.
Here,
we've got a paint where the bailiffs have been sitting and scratching the paint off on the wall.
Yeah.
The bailiffs are damaging the courtroom.
We've got some good painters, Judge.
Well, we can keep them busy.
The bailiff's belt is scratching the wall where they lean up against it. Don't eat the paint chips.
That's right.
Remember in the beginning when we started 110 years ago?
All right. Jurors are coming in.
And the record shall show that all parties are present and the jury is present.
Can we
Good
move the
morning to
paper,
all of
Judge?
you, ladies and gentlemen. Thank you for your patience as always, and we are ready to proceed in this case. I think when we broke yesterday, let's see, the state was still presenting its case in chief.
That's correct.
And the state may go forward.
Thank you. At this time, the state calls Detective Earl Boudreaux.
Detective Earl. Earl Buddha. Or Budapest or Budacrest or Boudoir. I don't know. I wouldn't know what his last name is. Boud something.
And raise your right hand, sir. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God.
I swear.
Please have a seat.
I don't remember the case that was from.
Okay.
The judge
10
said it,
degrees
though.
Clockwise.
Rotate the camera 10 degrees clockwise. One more degree. Half a degree. That's it. Stop.
Perfect.
Stop. That's it.
May I proceed, John?
You may proceed.
Good morning, Detective. Would you please state your full name for the ladies and gentlemen of the jury?
My name is Earl Boudreaux.
And Detective Boudreaux, how are you employed, sir?
I'm a detective with the Port Arthur Police Department.
How long have you been with PAPD?
36 years.
And undoubtedly well, you're certainly a certified peace officer, right?
Yes, sir.
And undoubtedly during your 36 years, you've received training, numerous training, I would assume.
You've seen some stuff.
And were you the on-call detective back on January the 11th of 2024?
Yes, sir.
Looks like
explain to
you're wearing
the
a
ladies
napkin
and
on
gentlemen of
this
the jury
shirt.
what being on-call means.
So we take turns a week at a time, and anything that happens after hours that they call you out. So that's basically what that was my week to be on call.
And you're not necessarily what we refer to as like a person's detective or
Right, I'm auto crimes.
auto crimes.
Yes.
But because you were on call that day or that week, you got called out to this particular scene on this particular, where you were called out to assist in this investigation back in January of 2024, correct?
Correct.
Are you familiar with the Last Call liquor store located at 2301 Gulfway?
Yes, sir.
That's in Port Arthur, Texas, correct?
Correct.
And that's likewise in Jefferson County, Texas, right?
Correct.
Now, as part of your involvement in the case, did you interview a Philip Bennett?
I did.
And as part of your involvement in the case, did you interview Ayanna Oates?
I did.
Now, that was essentially what you were tasked with, but you've also had the opportunity to review other aspects of this case, the evidence that was submitted as part of the reports and videos and that kind of thing, right?
Yes, sir.
Okay. And as part of that overall investigation, was a suspect developed in that or in this particular case?
There was.
What was the name of that suspect?
Trevontae Nichols.
And you understand that Trevontae Nichols is on trial here today, right? And prior to testifying here today, did you review a 911 call related to this case?
I did.
You know what I mean? I approached the evidence.
Yes.
The exhibits, I should say. Permission to republish state 70, please.
Any objection?
Oh, no objection to it.
It is allowed.
Republishing. We're going to play it again, huh? Why? You just play it over and over for each witness? Where's the question first?
Exhibit, Judge, I'm looking for the 911 call. Give me, that would be exhibit 1, permission to republish one.
What's your final answer?
It's my final answer, Judge.
Okay. I think 73 was part of a package of photographs. I'm looking at State's Exhibit 1 was originally admitted under with the testimony of John Boland earlier in the trial.
Okay.
Worst 911 call.
Hold on with your emergency. Hey, I just lost my life. Somebody just got this. Trevontae Nichols just got in my car while
That 911 caller, who did he say just shot at his car?
Trevontae Nichols.
As part of this case and your involvement in this case, did you have an opportunity to review the body-worn camera of Officer Gonzalez and also to review certain scene photos from the scene that were taken by ID Tech Bowler?
I did.
And were a number of shell casings marked by those evidence cones?
Yeah.
Have you, in your experience over the years, ever responded to a scene or seen a scene with that many shell casings?
No.
As part of those photographs, did you make any observations as it relates to any vehicles or buildings?
Yeah, there were several vehicles that were struck by bullets and several buildings or homes.
Based on your training experience and just based on your common sense and life experience, what could have been a result of if someone was either sitting in those vehicles or standing outside of the buildings at the time when those bullets were flying?
They could have had serious bodily injury or been killed.
And is a firearm considered a deadly weapon?
It is.
Capable of causing serious bodily injury, capable of causing death?
Yeah.
As part of your participation in this case, did you review certain video from the last call liquor store?
Yes.
As part of that video, did you observe a number of individuals in that, at least in that portion of the video that you reviewed, did you observe several individuals in that store?
I did.
Of those individuals, how many of those individuals were wearing red?
One.
Just one individual? I posted.
Lacey D, new courthouse next month. You're going to be at 24 months. You are already an OG. Thank you, Lacey D.
I'd like to republish 84,
Sorry, I missed you
85, and 86.
They have been admitted.
Why
you may republish?
Why do you just republish?
Did one, two, one, yes, one. There it goes. For the record, I am republishing State's Exhibit number 85, which I represent to you, Detective, is a screenshot from that last call liquor store video.
Yes, sir.
Does that look familiar to you?
Yes, sir.
And again, of those individuals in that store, at least in this screenshot, is it just the one individual wearing the red outfit?
That's correct.
State's Exhibit number 86, which has already been admitted into evidence, I represent to you, is a blow up or a zoomed in screenshot from that video. Does this individual in State's 86 represent the individual depicted here in State's 85?
Yes.
Is it the guy in this? Is this the guy in the picture we just enlarged? Is it the same as the one before we enlarged it? That was a weird question.
As part of your involvement or participation in this case, did you review certain video from the Valero gas station from across the street from the liquor store?
Yes.
Let's republish some screenshots from that.
Commissioner republished 71, Judge.
The judges, yeah, whatever.
I have to wait. Yeah. Very fast. Okay.
Still waiting.
What I'd like to do, Detective, is slow it down when we get to a particular portion of the video. I think I struggled with it yesterday, but I needed to open it with a different player, and I think I figured out which video player to open it with. At
least we can see some of the video now.
Detective, I think I'm close to the relevant portion. With the court's permission, there should be a pointer there close back to the right of yourself. And if you would use that pointer, now, and the court will allow you to stand and use that pointer to track. I think I know what I think you know what I want you to track.
Yes, sir.
When it gets to that point, please.
You know what I want you to track? Remember what we talked about.
Someone right here, looks like they're wearing all red. They're moving up towards the car that's driving off. Looks like they're pointing their arm out. Like you can see some muzzle flash right there.
All right. Muzzle flash in your training experience indicating what?
Firearm.
All right. Again, appearing to wear all red.
Right, correct.
Let's say if someone in your training experience if someone is being chased and shot at, based on your understanding of the law, do they have a right to defend themselves?
Yes.
Do they have a right to shoot back?
Yes.
Do they have a right to not only defend themselves, but what about other individuals in their vehicle?
Yes.
In fact, if you were being shot at, would you, if you had the opportunity, would you defend yourself by shooting back?
Yes.
If you were being shot at, would you feel threatened with imminent bodily injury?
Yes.
Did you have an opportunity to review the photos taken of the victim's vehicle that were taken by ID Tech Rebirth?
Yes.
And do you understand, based on your interview with Philip Bennett and Ayanna Oates, that that was the vehicle that they were traveling in?
Yeah.
And those photos taken by ID Tech Rebirth, what was some of the damage or the extent of the damage that you observed to that vehicle?
There were bullet holes in the rear trunk area of the car.
Okay. Bullet holes, anything else that may have been in that trunk of the car?
I think they found some bullet fragments in the trunk area.
Yeah, in your training experience, what would that indicate to you? If you've got bullet holes, a dial that shows the trajectory entering, that something, a projectile entered it, and then plus a bullet fragment in your training experience, what is that indicative of?
Probably somebody shot that car.
All right. And at least in a projectile, or at least a portion of that projectile, entered that car.
Correct.
Did you, I think we covered this, did you interview Philip Bennett and Ayanna Oates?
That night, yeah.
That same night? And have you interviewed few or many individuals over the course of your career?
Many.
Based on your training and experience, have you come to recognize or discern untruthfulness or deception?
Yeah.
And did you recognize any of deception or untruthfulness, at least in your opinion, with regard to Philip Bennett or Ayanna Oates?
I did not.
Based on your training experience and the evidence in this case, did you form an opinion as to whether or not an offense or offenses had been committed?
I did.
And what is that opinion, sir?
That an aggravated assault occurred.
Okay. Aggravated assault in violation of Chapter 22 of the Penal Code?
Correct.
And an aggravated assault as it relates to who? Who, based on your investigation, based on the evidence in this case and your participation in this case, who were the victims of that aggravated assault?
Mr. Bennett, Miss Oates, and their child, their infant child.
Philip Bennett, Ayanna Oates, and Messiah Bennett.
Correct.
And based on your review of this case and your training experience, did you form an opinion as to who committed that offense?
I did.
And what is that opinion?
That's Trevontae Nichols is the suspect.
And did you form an opinion as to whether or not Trevontae Nichols, in the process of committing the aggravated assault, threatened those three individuals with imminent bodily injury?
Yes.
And did you form an opinion as to whether or not Trevontae Nichols, in the process of committing the aggravated assault, in the process of threatening them with imminent bodily injury, that he did so by using or exhibiting a deadly weapon, namely a firearm?
He did.
And did you prepare a report or a supplement in this case?
I did.
And did you do it near the time when those events were still fresh in your memory?
I did.
And have you reviewed it prior to testifying here today?
I have.
That's all I have. I'll pass the witness. Thank you, Detective.
Go ahead. Thank you, Judge. Good morning, Detective.
Good morning.
Just have a few questions for you. Now, I understand that you say you normally work auto crimes, right?
Yes, sir.
So whenever you arrive as the detective on duty or at a scene, how does that normally work for your command with the rest of the officers or ID techs who are at the scene?
So when I get there, the officers usually, and if there's the ID scene techs are on duty, they're there before me, and they give me a summary of what they found so far, what's going on with the case.
Okay, so basically, like all the casings and everything that was found, that was already collected, but then that information was given or shared to you at that time.
Correct.
Okay. Now, my understanding from testimony we've had here earlier, it was about 79 casings found out there that night.
That sounds about right.
Was it ever determined how many of those casings or shells would have been coming from Mr. Bennett firing that evening?
I can say from my interview with him, he fired what he claimed was like 3 magazines.
Yes, sir. And 3 magazines would approximately be how many bullets?
30 at least.
somewhere around
45.
60.
So around of the 79 that was fired, about at least 60 of them, in all honesty, came from Mr. Bennett.
Probably.
That's the victim.
Now, also, from previous testimony, we haven't, because we had some discussion about clusters of the casings. Are you familiar with that?
This case is a cluster.
Yeah, just what I saw in the pictures.
Okay. Now, typically when there's clusters of casings, what is that indicative of?
That someone was standing still when they were shooting.
Someone was standing still when they were shooting. Okay. And does it take a certain number to indicate for it to be called a cluster of casings, or just?
I guess that's just an opinion.
An opinion?
Yes.
Okay. Now, in one, or at least one cluster of casings, there was a wallet found. Is that correct?
I believe so, yes.
Okay. Did you ever determine who that wallet belonged to?
I don't know.
Was there ID or anything in that wallet to identify who the owner was?
I think there was, but I can't say for sure.
Did you ever check the ID of a wallet?
Who is, to your knowledge, who is Darian Daughtry?
So,
you know who Darian Daughtry is?
No.
Okay. So you would be surprised to know that was the identification of the wallet. It would belong to Darian Daughtry.
Okay.
It's a new name.
So was there any additional investigation or follow-up into a Darian Daughtry or the owner of that wallet in the midst of that cluster of casings?
Not by me.
Not by you? Now, but if it was any type of follow-up by another officer or something, it would have came through you. Is that correct?
No.
As you, as the detective who was over the case or responsible for it, it wouldn't have came through you?
I was called to the scene. The case was not assigned to me.
Okay. Well, who was the case assigned to?
One of the major crime detectives.
Okay. So how does that work? So you basically just work the scene and then it's passed on or assigned
Correct.
at that point? So but to your knowledge, we don't know have any information or anything about who this Darren Daughtry was or their involvement?
I don't know.
Okay. Now, also, we talk about the red clothing.
Yeah.
Now, is that something that would you consider unique in that area, or during that time see someone out with a red hoodie on?
Not necessarily.
Right. So it's not something. It's not that unique or distinct to see someone in some red clothing.
Not necessarily.
Now, at the time, did you personally interview Miss Oakes and Mr. Bennett?
Yes.
You interviewed them separately?
Yes.
So when you talked to Miss Oakes, did she at any time say that she saw Mr. Nichols shooting at her?
No.
Did you ask her about who shot at her, or if she knew who shot at her?
I'm sure I asked her what she saw, to tell me what she saw.
And in no time she told you that she saw Mr. Nichols shoot.
No, I recall, no.
Once you had your interview with Mr. Nichols, Miss Bennett and Miss Oakes that night, did you do any follow up with them for any additional interviews?
Mr. Bennett came in a few days later, and I want to say I typed up a statement from him.
Oh.
The original interviews and statements were videoed.
So, but nothing from Ms. Oakes?
I recall them.
Okay. After your involvement at the scene, securing the scene of the incident, and getting those interviews, what additional responsibilities or involvement did you have after that?
No.
So, 1 second. I pass it with the judge.
No further questions for this detective judge.
Is this man excused?
Yes,
All
sir.
right.
You are excused, sir. Thank you. Next, please.
It's time to stay at Texas rest.
They've rested.
All right. The state has rested its case.
Do we need a break?
What says the defense?
Defense register.
The defense also rests.
No
All
judgment.
right, ladies and gentlemen, the parties have rested. That means the evidence is before you. I am finishing up the preparation of the jury charge. I can't finish it until both parties say they rest. So now we can close the door on the jury charge, which I'm going to need maybe 15 more minutes. But I'm going to ask you to relax, stretch your legs. Hopefully we can bring you back and read the jury charge to you. Then the lawyers will make their final arguments and you will begin your deliberations. That's our plan. Okay, thank you. Everyone else remain seated while the jury exits.
There they go. All right. The jury's about ready to do their duty. They're just taking a sharp break first. I was thinking at least call the defendant to the stand. What does he have to lose? He could have said that, that.
All right, the jury has exited. I've got a prepared jury charge. The one thing I don't have in it, though, is the law of parties. What do y'all say? The evidence sound. There's more than one person involved here in this event, and I've got the parties' instructions and what the parties want here.
I think the state's inclined to forego a party instruction, Judge.
Is that what you?
That's what I want to do. I think that video, at least that instance before the alleged other exchange of gunfire, I think it's indicative of this defendant acting alone, at least at that instance. And I think that's what the evidence would support.
All right.
I'll be fine with that, Judge.
Okay. Then the court is going to exclude this then. And here's the jury charge. Passing them out to the attorneys. Please review those, see if there's any changes that need to be made, and we will be ready to finalize and do arguments. Thank you.
All right, so the judge is going to take just a wee break as well. And we're going to get ready for closing arguments. This has got to be a public defender. I can't imagine someone paying good money out of their pocket and getting this level of, I don't know, you get some companionship. You get somebody to sit with you during court so you're not alone. That helps. But win, lose, or draw, the public defender gets paid the same. I'm not saying public defenders are bad. He's dealt an awful hand. He's got video evidence of his client in HD committing the crime. So maybe his client refused to go along with the. I mean, he's asking for a trial. He has the right to a trial. Refused to plead guilty. Let's see. We need to remember the sharp break soundbite. We need a time where he says it the clearest, with no one else talking in the background and not me talking over it. That's the harder one, without me talking over it. All right, the poll's up. Thank you very much, Georgia fan, for that one. The poll is Trevontae Nichols guilty as charged? The options are no or yes. Pretty clear cut. Gred, thank you very much. Tell you what, you send me this timestamp, I'll make it happen. Surprised they didn't do law of parties. The one big piece of evidence we got out of the prosecution's final witness was on cross-examination, where defense asked him to figure out who shot most. And the victim, Mr. Philip Bennett, admits to dumping 3 magazines of about 20 rounds each at the crime scene. And by dumping, I mean pow, 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 pow. That's 10, so that's one clip, and then doing that 3 more times. It must have sounded like Fallujah in there. The law of lead. He with the most lead wins. So it's no surprise that the defendant, or the victim, Philip Bennett, is in custody right now, facing firearms charges. That'd be a good one. Yeah, it sounded just like a real thing, right? You could probably tell that was a 45. Pow, 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 pow. Oh, man, Jacob Knowles just dropped his video of this boat getting launched. I know, I watched the boat getting launched already, but he dropped a video of the boat going from where he built it to where he launched it. The scariest moment of my entire life. It's awesome. Joe Sherlock asks, R.A., does trials ever depress you or make you lose faith in the justice system? Joe, there have been times where I felt that specific courts did not have the pursuit of justice at their center, but the system in general I have great faith in. It is depressing to see something that I feel that either someone was very guilty and they were found not guilty. That's not as bad as when I feel someone is innocent and they're found guilty. That's the harder one for me. I would rather have guilty people go free than innocent people go to jail. So definitely more difficult when I see someone who I feel is being blamed for something they did not do. I was watching the lobster video. Yeah. Can't wait to watch that one. I can't watch it right now, but the peacock howling lady was appalling, though. It's pretty bad. I mean, there's some people who belong in the system, that's for sure. I think she might be one of them. But no, generally, I feel I love this legal system. I love the presumption of innocence. I love the legal framework that they operate in, the rules of evidence, which seems fair. Right? Sometimes you walk into a situation you're like, you should know everything. The jurors should know everything that's happened. And I used to be more of that mindset. Now I understand there has to be boundaries. There has to be a rule that we only are talking about what the state is saying happened. We're charging you saying this happened. Did it or didn't it? Sometimes some of that extrinsic information is relevant and sometimes it's not. But there we go. 3-day poo trial with a with tag. Hold, please. Let's see. And time 1:45. Let's listen. Let's listen a little bit. See what you got. Oh, I need to plug it in. All right. Now we send it here. Wrong plug. There we go. You can hear the difference already. Okay, 1:45:45.
It's up to par because it looks as though I'm missing information to both cases.
You claiming a discovery violation?
Here's what we're going to do, ladies and gentlemen. We're going to take a sharp break.
We're taking a sharp break, guys. That one's a tough one, Red. I grabbed it, but thinking there might be a cleaner one I might be able to find. Because he stutters during it. And he, you found it using the transcript. Did you look for shart or short? You like the stutter? We're going to take a shit. Yeah. Okay, now I'm with you. Okay, I'm with you now. I like the stutter. Okay, we'll use that. Here's the catch, though. I have to put my soundboard. I have to put this soundboard, which you can't see because it's underneath, in this one with all the colored lights. Why can't you see that? There you go. I have to put that in podcast mode to transfer the file, which means I can't talk during that time. So I'll be muted. And hold, please. So it's just going to be quiet for a second. We're going to go back to this.
Charge as requested by the parties. Have the parties had an opportunity to review? And are there any corrections or changes to this proposed jury charge, State of Texas?
The state has reviewed, and there are no proposed changes to the charge.
And defense?
Defense reviewed as well, Judge. No opposed changes.
All right. Then it will be read as agreed upon and proposed. And please bring the jury in. And also the parties have requested me to alert them if they get to 15 minutes so they know where they are in the final argument. You have a reasonable amount of time to make your final argument.
The time limit is reasonable and alerts at 15 minutes. All right, jury's coming in. It's going to be quiet just for a minute. What's up? What's wrong, Amber? What did I do now? Hold on a sec. Okay, I'm going silent. I'm going radio silent. We're bringing the jury in. I'll be right back. I'm making a link. I was repeating exactly verbatim what it said on the screen. It's the shit and then shart. Okay, hold on. All right, we are back. Transferred the files. Jury still isn't here. Jury's taking their time.
And the record shall show that all parties are present and the jury is present. All right. We are ready to proceed. I think we are about to close the presentation of evidence. And I'm going to ask each of the parties, beginning with the state of Texas, is there any further evidence the state wishes to proceed in these three cases?
The state both rests and closes, Your Honor. There is no additional evidence.
And defense?
Yes, Judge, there is no additional evidence from defense in this matter, but
all right, ladies and gentlemen, the evidence is now before you, and at this time, I'm going to read to you the jury charge, which contains the law applicable to this case for your deliberations. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will as I read this charge to you. This charge will be left with you to refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment in cause number 24 CR 300 with the offense of aggravated assault with a deadly weapon alleged to have been committed in Jefferson County, Texas on or about January 11th, 2024. The defendant has entered a plea of not guilty to this indictment. Additionally, the defendant stands charged by indictment in cause number 24 CR 301 with a second offense of aggravated assault with a deadly weapon involving a different complainant than the case described above, alleged to have been committed in Jefferson County, Texas on or about January 11th, 2024. The defendant has entered a plea of not guilty to this indictment. And lastly, the defendant stands charged by an indictment in cause number 24 CR 302 with a third offense of aggravated assault with a deadly weapon involving a different complainant than the two cases described above, alleged to have been committed in Jefferson County, Texas on or about January 11th, 2024. The defendant has entered a plea of not guilty to this indictment as well. Our law requires that I submit the following charge to you in these cases. This charge contains all of the law necessary to enable you to reach a verdict or verdicts. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and the terms used in the charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with a deadly weapon. A person commits the offense of aggravated assault if he commits assault and uses or exhibits a deadly weapon during the commission of the assault. Deadly weapon. Deadly weapon means one, a firearm, or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or two, anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using energy generated by an explosion or burning substance, or any device readily convertible to that use. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Defendant's election not to testify. Our law provides that a defendant may testify in his own behalf if he elects to do so. And this is a right given to a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations, or take it into consideration for any purpose whatsoever. Charge. Now, there's a separate charge for each indictment, and they are going to be similarly worded. Please bear with me. As to cause number 24 CR 300, charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about January 11th, 2024, the defendant Trevontae Nichols did then and there intentionally or knowingly threaten Philip Bennett with imminent bodily injury and did then and there use or exhibit a deadly weapon, to wit, namely, a firearm, during the commission of said assault, then you shall find the defendant guilty of the offense of aggravated assault with a deadly weapon. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. As to cause number 24 CR 301, charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about January 11th, 2024, the defendant Trevontae Nichols did then and there intentionally or knowingly threaten Aliana Oates with imminent bodily injury and did then and there use or exhibit a deadly weapon, to wit, a firearm, during the commission of said assault, then you shall find the defendant guilty of the offense of aggravated assault with a deadly weapon. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. And finally, in cause number 24 CR 302, charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about January 11th, 2024, the defendant Trevontae Nichols did then and there intentionally or knowingly threaten Messiah Bennett with imminent bodily injury and did then and there use or exhibit a deadly weapon, to wit, a firearm, during the commission of said assault, you shall find the defendant guilty of the offense of aggravated assault with a deadly weapon. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense or offenses is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. There are 3 separate indictments for the jury to consider. Each indictment should be considered individually based upon the evidence presented during the trial. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in each of these cases. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider it themselves at arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Physical exhibits have been introduced. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys present their arguments to you, you will retire, select a foreperson, and consider your verdict or verdicts. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your consideration of and evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict or verdicts attached to this charge. In returning your verdict or verdicts, it is your responsibility to make certain that justice is done in each of these cases in accordance with the law and the evidence. Now, in each particular case, we've got a separate cause number and 2 verdict options for each case. In cause number 24 CR 300, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, a place for the foreperson to sign. The other option, we, the jury, find the defendant not guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, with a place for the foreperson to sign. As to the second cause number, 24 CR 301, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, a place for the foreperson to sign. And as you're catching on pretty quickly, there's a second option. We, the jury, find the defendant not guilty of this offense as charged in the indictment, with a place for the foreperson to sign. And finally, in cause number 24 CR 302, we, the jury, find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in the indictment, with a place for the foreperson to sign. And we, the jury, find the defendant not guilty is your second option, as similar in each of these three cases of the offense of aggravated assault with a deadly weapon as charged in the indictment. Of course, only one verdict can be signed on each case. And also, what I've done for you is so that you're not confused and trying to recall what numbers apply to which cases. The introduction page will set forth a paragraph for each cause number, which will refresh your memory to the evidence. All right, under the rules of criminal procedure, the state of Texas may open and close final arguments. What says the state?
Your Honor, the state will waive its right to open, however, reserve its right to close.
You
take
may.
a short break.
And Mr. Lewis, when you are ready.
Take
Thank
a
you,
short
Judge.
break.
Good morning, everybody. This will be the last time I get to talk to you all about this case before you go to make your decision.
Take a short break.
And nope, I'm not going to take up too much of your time. I just want to kind of point a couple of things out to you. Now, you remember from the start, we talked about perception and reality. Or is how sometimes people's perceptions can get merged into their reality. Okay. And we talked about that hypothetical car A hitting car B and how, it takes the opportunity for whoever the trier of fact is to be able to hear everything and see everything in order to make their decision. Okay. So the first thing I want to definitely point out to you is that all the evidence that has been presented here and entered into evidence is available to you. So any of the videos or photographs that you would need to look at to help make your determination, you can look at. It'll be here for you. Okay. So let me go through a couple of things I want to point out to you. First thing is those red clothes. Because it's been talked about how that he was in this red distinct warm-up sweatsuit and pointing that out. Now, I will say, yes, if you look at the partial video from inside that store, yes, he is the only one in red. So it would look like that would be pretty unique. Something pretty unique, especially to him, right? But look at the rest of the videos. You look at the video from across the street, will give you a full view of the neighborhood and the people out and about. You're going to see about 2 or 3 people in red sweatshirts and hoodies and sweatpants. So it's not that unique of a thing to wear the color red or be in a red sweatsuit. So that's definitely something for you all to keep in mind and consider. Now, what's also really important for me to point out here, and it didn't really come up a lot in this trial, but it's definitely very important, is that we had a lot of talk about all the shell casings that were found out there, okay? About where they were, how they were positioned. And you see a lot of that on from the body cam footage from the ID tech when they're putting the cones out and notifying where they all are. And they're talking about how when you see a cluster of them, that's indicative of where the shooter was or where someone was standing and shooting. And you will see from the body cam footage, you'll see them pick up a wallet. That wallet is that Darren Daughtry person. And you actually see them look at the ID in the body cam footage. And when they take a look at that out and look at it, and so you're telling, the evidence that you're seeing, from the physical evidence you're seeing, is already telling you that there's a possibility of a shooter named Darren Daughtry among these cluster of bullets or shell casings. But that was never followed up on. It was never looked at who this person is, where this person is, what this person looks like, or any of that information. And that is not our responsibility. That's the responsibility of the investigating unit that's taking care of this case, right? Now, so that was all we had from that, but we know that's always out there. We don't know. And then we get to the statements of Ms. Oaks and Mr. Bennett. The first statements we get from Mr. Bennett, of course, come from the 911 call. And you do hear him saying the 911 call, Trevontae Nichols. He does say my client's name. But then you also hear him say, somebody was shooting at me, which tells me that he's not clear about who it was that was actually out there shooting at him. So maybe it was just him recognizing him from school, or seeing someone from earlier, or seeing someone in a red sweatsuit and trying to make that connection. Like we talked about, perception versus reality, how he got to that point, right? So it may not be from actually seeing him do anything or knowing he did anything. We get to Ms. Oaks, and Ms. Oaks said here on stand that she saw Trevontae Nichols shooting at her, or shooting at the car. That's the first time we've heard that in years. Detective Boudreaux, who did the investigation and did the interview with her, interviewed her and talked to her about everything that happened in the office. He talked to her about who was involved and who did this. At no time did she tell him that she saw Trevontae Nichols shooting at her, or her child, or her child's father at that time. So this is the first time we're hearing about this. Why now? Why now to come up here and say something like this? We had Mr. Bennett here. Of course, Mr. Bennett did not say that he did not make any testimony about Mr. Nichols shooting at him, or that he recognized him or saw him in the store that night, which that's clear to everybody. They were in the store that night together. And you see it that, and from the video, they're in there for, I won't say a significant amount of time, but enough time to where when they see each other, there's no issues, no problems, no argument, no staring up and down, nothing. And they both talked about their prior relationships before that night. There was no issue, no beefs, we don't know how we even get to this point. Now, I know it's a lot for you all to have to digest because you have 3 different cases, 3 different indictments to decide on and to make a decision on. So I'm going to help you in the best way I can. You have 3 decisions to make. First, let's talk about Messiah Bennett. Okay. My client is charged with intentionally and knowingly firing that weapon.
No, it's
excuse me.
Intentionally or knowingly.
Or knowingly firing that weapon, of course, at Messiah Bennett. Thing we know here is that he did not intentionally or knowingly fire Messiah Bennett. One, because either my client or even whoever was firing out there had no idea Messiah Bennett was in that vehicle. Okay? So when it comes to making a decision in regards to Messiah Bennett in regards to this charge, it will be not guilty. All right. Same thing with Ms. Oaks. She testified she never got out of the car. Windows were tinted. There was no way for anyone to know there. So whether it was my client or whoever that may have been involved with this situation.
Your Honor, I'm sorry to interrupt his closing. However, I feel compelled to object because I think that's a misstatement of the law. I think the law says he just needs to intentionally or knowingly engage in the conduct. It's not a proper argument to say, well, he didn't know that person was in the car. The argument would be he intentionally or knowingly engaged in the conduct.
The instructions of law are provided to the jury from the court, and I trust this jury. They will follow the law as it has been stated when the law was given throughout the trial by the court and also in this jury charge. I trust them. They will follow the law. And please recall the evidence. That's your most important factor in your deliberations, ladies and gentlemen. That's your job. Determine how much weight and credibility to be given to the evidence presented. Go ahead.
No problem. Thank you, Chuck. And that's what I asked you, of course, is to always go back to the evidence, whether it's the testimony or the videos or any photos. Okay. But when it comes to Ayden Oaks, excuse me, it's the same thing. It's not guilty. He's not guilty of any aggravated assault when it comes to Ms. Oaks. And then we got Mr. Bennett, which is more questionable because you can say he did see him, he did know him, but there's nothing there that shows that the state has proven beyond a reasonable doubt that my client committed any aggravated assault against Philip Bennett. That burden of proof stays with the state. That's already been explained to you. That's been talked about in the jury charge. That's your obligation is to hold them to that. And when you look at all the evidence, totality of the circumstances, everything you get to see, I'm sure that you'll decide as well when it comes to Mr. Bennett, you're going to be able to find that my client is not guilty of that offense. Thank you, Butcher.
State.
May it please the court?
Yes, sir.
Mr. Lewis, ladies and gentlemen of the jury, I want to begin by thanking you on behalf of the district attorney's office, on behalf of our community, and of course, like I began with jury selection, on behalf of the victims, Philip Bennett, Ayden Oaks, and Messiah Bennett. I want to thank you on their behalf for your time and your attention in this case. You know, there's always a concern with lawyers in opening statements of being too hyperbolic or overselling the case, making statements that the evidence does not live up to. Looking back, I submit to you, I believe my characterization of this scene and what occurred out there earlier as being indicative of something you'd see in a shootout or in a war zone. I think it was the evidence supported that. I mean, you've got these ungodly amount of number of shell casings and shots being fired. You've seen the video. The poor people at that gas station were ducking down for cover, fearing for their lives. And you see the bullet holes in these buildings, some of which went all the way into the last call liquor store, the multiple rounds that went into that GMC pickup truck and into that Nissan. I don't feel like it was oversold to you, the seriousness and the dangerousness as it existed that night. What I would like to do, not unlike what Detective Boudreaux did, is just recap the evidence. And you've heard the evidence and the testimony in this case. You have seen those videos. They're in evidence. Particularly that video that from the Valero that we've enlarged. Feel free to watch that if you want and take a closer look at that. Take a look, if you choose to, at the last call liquor store video, surveillance video that shows the demeanor, the change in demeanor with regard to this defendant when Philip comes in. I think that's indicative or probative and important. Also, I'd ask that you use your common sense in evaluating this and evaluating the testimony. I mean, either you believe Ayden Oaks when she testifies that she saw Trevontae Nichols firing the shots, or you don't. You know, either you believe that 911 call that Philip Bennett made, that you heard from the equipment there, that it was Trevontae Nichols that fired at him. Either you believe him or you don't. I guess either you believe that the individual in that video or all red left that store and drove away from that or left that parking lot and went on about his business, or either you believe that, or by some unfortuitous stroke of bad luck, someone moments after this defendant left that store dressed in all red, another individual came up dressed in all red and fired those shots at that vehicle as it drove away. We talked about this in jury selection about there being doubts and about there being reasonable doubts. And I'd ask you to use your common sense, you know, based on the testimony, based on that evidence, the video, uh, uh, is it a reasonable doubt that only mere moments after this person dressed in all red leaves that liquor store, that somehow another person dressed in all red comes from behind or on the side of that store and fires those shots into that vehicle? I'll submit to you that it doesn't pass that test, that it is not common sense. Another thing I want to address is something that Mr. Lewis brought up, this whole notion about the evidence must show that someone intentionally or knowingly knew that someone was in that vehicle. That's not my understanding of the law. You can read the jury charge yourself. It's a little splitting of the hairs. There's some minutia there, but here's my understanding of the law: that a person simply must intend or knowingly engage in the conduct that causes the result. Because think about it. If all the defendant has to do is to come in here and say, I didn't know that baby or that person was in the car or in the building that I shot up or in the house that I shot up, and that would be a defense, then that's what each and every defendant would say in each and every case. I didn't know they were. So that's why my understanding of the law my understanding of why the legislature worded the law that way is because intentionally or knowingly goes to the act, not to intentionally or knowingly having to prove that they knew that person or persons were in the vehicle. So that's my take on it. If you read it, the jury charge, you make that determination for yourself. Another thing that determination that you don't have to make is the why. You don't have to determine why he did what he did. You don't have to figure out if there was some previous beef, some previous relationship that soured. There's nothing in that jury charge that will require you to prove or require me to prove and require you to find the why. It only requires that I demonstrate that this defendant intentionally or knowingly threatened serious bodily injury to Philip Bennett, Ayanna Oates, or to Messiah Bennett, and he did so with a deadly weapon, namely a firearm. That's all I have to prove. I don't have to prove that the why or the beef or if. I mean, who knows why he did it? I mean, I don't have to prove whatever defect he may have, whatever malfunction may be going on. Who knows? Had a bad day, didn't like the way Philip Bennett was dressed that day. Who knows? It's not something I have to prove. Okay? All right? So I would submit to you not to get caught up on that. You've got the evidence before you. You heard the testimony from Detective Bujo that the shots that were fired by Philip Bennett were in self-defense. You watch that video, it is clear this defendant is firing on that vehicle without being fired upon first. So whatever actions taken by Philip Bennett with regard to firing and the number of shots he fired, I submit to you that they were all in self-defense. You've got the opportunity here you've got both the opportunity and the evidence to support that conclusion of finding this defendant guilty, okay? And guilty, not because I say so, because Detective Boudreaux says so, but because it's what the evidence demands. We talked about this in jury selection about the pieces of the puzzle. Would it have been great to have unequivocally clear video from across the street that shows this puzzle and clear? Yeah, it would be great. But I don't like that puzzle with 98% of the pieces and 2% of the pieces missing. We don't always get that 100%. But I submit to you that, like we talked about during jury selection, you have here enough of the pieces of the puzzle to find this defendant, Trevontae Nichols, guilty of the offense of aggravated assault, guilty of threatening Philip Bennett, threatening Ayanna Oates, and threatening Messiah Bennett with serious bodily injury with a firearm. And I'm asking you to find him guilty. I'm asking you to find him guilty of that offense based on the evidence, based on
I think he should have pointed out that the defendant at best fired what?
Stand by, I've got to get the big stapler.
19 rounds if he was
They
the
give me
only
the
other
small one.
person shooting. But they had 4 guns there. So he might have fired, let's see, 60 from one person. And then 19 divided by 3.
All right, this time, ladies and gentlemen,
Maybe
I'm going
8.
to tender the jury charge to the bailiff. I'm going to ask the 12 of you to, in the jury box, to please follow the bailiff into the deliberation room. We will await your verdict or verdicts. Now, the alternates, by law, the law does not allow more than 12 people in the deliberation room. I'm going to ask the alternates to please stand vigil. We have had to replace jurors in the past. I've tried 617, and we've even had to replace jurors during deliberation. So we're going to ask you to stay with us until the end. And thank you for being here, and thank you for being ready, willing, and able to get into the game in the event a juror is unable to continue. Okay, thank you. All right, the 12 will follow the bailiff, and the alternates, please stay close by, and we'll keep updating you. Thank you.
We haven't done a poll on how long they'll deliberate. What were the results on the other one? About 83 to 17, 83% guilty. Stand vigil. Short for vigilant. Hold your eggs, right? Just wait for the timer to stop. Door to shut. Everyone to leave. I'll start the timer here on my end.
Practice over the other. We are in a recess awaiting a verdict.
We're in a recess, not recession. Just in a recess awaiting a verdict. I guess in an hour or so, should we do a poll on deliberation time? I don't think it's going to be very long. I'll say this. It was, I think, disingenuous of the prosecutor to talk about how many shots were fired, blaming the defendant for that, if he knows that one of his witnesses contributed 60 of the 79 shots that were fired, and that there were 2 other shooters. That's a lot. That's a lot of shooters when you do the math. Let's see. Very dramatic. About an hour. They do have 3 charges. Curious about what the jurors will think about the law when it comes to the 2 people in the back seat that he did not know about. If the wording of the law tends to make them think that the shooter had to know that they were there in order to commit that crime, that'll be interesting. Let's see. We're going to do some court hopping while we wait. Judge Simpson, he's got a criminal docket going on. Let's jump up to Judge Simpson for a little bit.
I'm sorry. I'm here. I'm present.
We are too.
Okay. Can you turn your camera on? Yes. This is me. Okay.
Detroit
All right.
Lions.
State your name.
With the ceiling fan for the
My
jury.
name is Michael Mayberry.
All right. What are we doing? There should be a plea form in the file, Your Honor.
There is.
Tiana Allen is in the dark.
Plea form indicates the defendant's going to plead to the charge under 257-326, allowing an eligible driver to operate a motor vehicle to 90-day offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. State your name. My name is Michael Mayberry.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of allowing an eligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Do you understand that by pleading guilty, you'll not have a trial of any kind?
I do.
You signed or had cause to be signed an advice of rights on your behalf. Is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
You understand you're waiving all those rights, including the rights contained in paragraph 5?
I do.
Where are you going? Okay. You understand you're giving up your right to appeal of right?
I understand.
But do you overstand?
Are you on probation?
There's our timer.
I am not.
Did you say I am not?
I am not on probation, no.
All right. And you're not on parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
I am.
And also because you believe that you're guilty of this offense?
Yes.
June 9th, 2026, at the location of eastbound I-94 in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
I did.
Did you allow someone who is otherwise ineligible, maybe yourself, to operate that motor vehicle?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. Count 2, count 1 is dismissed. Sir, anything you or your attorney want to say before I impose sentence?
No. I just want it to be clear for my obligations after this judgment.
What?
Okay. I don't know what that meant.
I just want to make sure that I know what I have to do, because this is the judgment that has been made. Because this judgment has been made, what do I have to do to not have y'all looking for me or anything like that, is what I'm saying. I just want to be clear of what my obligation.
I'll be looking for you to stay out of trouble.
Just don't screw up.
Obviously, I was only trying to take my son.
Otherwise, I'm going to be looking for you.
I was
know. Traveling to get in that truck and we'll just roll up on you.
Respect. Yeah, no, I just don't want y'all looking for me. I was only trying to take my son to practice. I'm not doing no BS or dumb stuff. But I just want to know if I got to pay this, I got to pay this. I just want that to be clear. That's all I'm saying.
Mr. Mayberry, after the judge imposes a sentence, I will send you text messages with what you have to do for your next steps, okay?
Respect. Yeah, just like you sent me the text message and I didn't know what time I had to go to court or what by Zoom.
Always,
I had to find
I've been helping
that
you
out.
so far. I will continue to help you after this court date. But let's let the judge do his thing.
Respect.
Now be quiet and let the judge talk.
Talks a lot. That's why people are looking for her. Fine can cost of $250. I'll suspend 90 days in jail. Young man, when can you get that paid? Why you look at me like that?
Hold on. $290?
90 days in jail. Wait, hold on. I just want to make sure I understand.
90 jail suspended means as long as you pay your fines and costs, you won't have to worry about jail.
How much time I got to do that?
That's what the judge was about to ask you, is how long you needed.
Okay.
You're killing me, man.
No, I'm so sorry. I just don't want to do.
You're killing me.
I'm sorry. I'm not trying to step on the line here. I
pass more intense sentences on other stuff. I just give him this sentence, and this is taking forever.
This is live.
I'm sorry.
I got a hint. I know why people are looking for you. Every time somebody does something, then you got something to say. Don't put your hands up. I'm not the cops. Put your hands down. All right, listen. Mr. Mayberry?
Matthew Brown's cracking up. So is Sean Moyer.
How long do you need to pay this?
Is 2 weeks too long?
I thought he was going to ask for some months.
No. I ain't finna play with you. I ain't finna play
Mr.
with you.
Mayberry,
Yes, yes,
no,
sir.
you're all right, man. Get do this. Get it paid by the end of September, okay?
Respect. Thank you. Thank you so much.
All right.
I don't
Mr.
mean to
May-
be. I don't mean to be difficult, and I'm sorry. But yes,
No, Mr. Mayberry, you're good. I was just trying to get through it. You thought bad things were going to happen. I knew bad things weren't going to happen, but you were just trying to protect yourself. I get it. Sometimes, though, you just have to listen and then respond. You respond, don't listen, and then everybody got to try to. All right. Mr. Mayberry, you take care. You have a great day.
I'm sorry. You too. You too. I promise you, I got that for you. Yeah. I'm trying to get better at that. Yeah. I'll see y'all later.
Okay. All right. Take care.
Yes, sir.
Mr. Mayberry, if we sent you for a drug test
Court
right
calls
now,
the case, People versus Sean Moyer.
what would it show?
And Assistant Public Defendant Nichols Bukovich on behalf of Mr. Moyer. I'm still up here.
Sean's right here.
Mr. Moyer?
Oh, he just left.
I'm here. You got a camera? Okay. What are we?
Your Honor, I believe the result of this one is going to be a civil infraction. My understanding is the defense is going to admit defense counsel is going to admit responsibility on careless driving. 257.626B upon acceptance of that and dismiss the original.
That's correct, Your Honor.
That's a correct statement?
Yes, Your Honor. Sorry, my brain was catching up. The last one.
All right. No, it's okay. Okay. All right. Mr. Moyer?
Yes, sir.
All right. Do you admit responsibility to the fact that
Got to find the paperwork.
That on or about October 8th, 2025, at location of Michigan near Fosdick Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle in a careless fashion?
Your Honor, my client has given me permission to admit responsibility on his behalf for this matter.
Okay. On behalf of your client, do you admit responsibility with that?
Yes, Your Honor.
I understand. I get why. Court will accept counsel's admission to count 2. Count 1 is dismissed. What do we have to say?
We don't want him to say it because it can be used against him.
Fines and cost of $200. Sir, when can you get that paid?
End of next month.
You just listened to the last case. See, why is everybody playing with me today?
Matthew Brown's hoping his case goes this smoothly.
September, it's Ann's fault. September 30th, 2026. Thank you, sir.
Thank you, sir.
Who's hiding behind me?
Court calls the case. People versus Shaylin Nichols.
Good afternoon, Your Honor.
And Assistant Public Defender Nichols Bukovich on behalf of Ms. Nichols. You'd be appearing via Zoom.
She was there, but she is not.
Yes, Your Honor. She did text me. She was on the Zoom. She did leave the meeting because her phone was on low power. I did tell her I would text it. This is the information I have, Your Honor. She was on Zoom for a while.
It's only
see
noon.
her.
Your phone's
We were
already
going to
dead.
have to set this matter for final settlement conference.
I need her.
I did text her to let her know you're going to get back on the bench if you may briefly pass the matter.
You text her to a dead phone.
Yep.
She told me she was getting off the Zoom to save her battery, so I assume she may still have a reception. Or a battery, I apologize.
I'll pass it. See if you can
Charge your phone.
get her back on. Oh, my goodness. Court calls the case. People versus John Smith III.
The third.
And Assistant Public Defender Nichols Bukovich on behalf of Mr. Smith. All my cases are right now.
Yes, I know. Mr. Smith, can you state your name, please, sir?
John Smith III, Your Honor.
All right. How's your battery on your phone?
83%, Your Honor.
There you go. That's what I'm talking about. Just plug it in. All right.
Somebody's going to come along and ruin this.
What are we
mood.
doing on Mr. Smith's case?
So we are asking to set this matter for final settlement conference. I have spoken to APA Cook. There would be no objection to setting it for this final settlement conference docket this Friday if the court is open to that.
Jury final settlement conference, October 7th, this Friday, 2026, 9 a.m. Did I say October? Yeah. What are you correcting me? No, never mind. Thank you. August 7th, 2026, 9 a.m. She's been looking for the whole semester to just correct me. That's at 9 a.m. Jury selection if necessary. August 10th, 2026 at 8:30. Both of those proceedings are in person. All right. Thank you, sir. We'll see you then.
Your Honor.
83%. See? That's how you do it.
Mine's 100.
Court calls the case. People versus Kristen Stamper.
Good afternoon, this is moving to another lawyer hearing on behalf of Ms. Stamper. Ms. Stamper, state your name for the record, please.
Oh, there she is.
Thanks for dressing appropriately for court.
You have to unmute, ma'am.
Kirsten Stamper, sorry.
No, it's okay. Thank you.
We're asking for another control.
We're going to take a poll. Like how much power people have on their phone.
Let's do it.
Listen, I got 15% and my phone is plugged in.
There you go. No, you're good. All right, go ahead.
So Ms. Stamper just wants to watch the video. It should be in the mail on the way to you, Ms. Stamper. So just need a little bit of time for that to occur.
All right. I'll adjourn this to September 2nd, 2026, 9 a.m. All right. Thank you, Ms. Stamper.
Thank you, Judge.
Court calls case. People versus Sierra Sutter.
People.
And Assistant Public Defender Nichols Bukovich on behalf of Ms. Suter, who
is not
present in the courtroom, and I'm not sure if she's present on Zoom.
Bench warrant.
Not checked in.
I tried to reach out to my client. I was unable to make contact. I would request an adjournment.
Maybe your phone was dead.
Bench warrant will issue bond 5,000, 10%.
Thank you.
Warrant will issue immediately. Court calls the case. People versus William Talley Smith.
Good afternoon, Your Honor. Raymond Cook for the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Callie. Your Honor, we have attempted to get in touch with Mr. Callie since multiple times. We've unable to do so. Peter Roberts Bill.
Talley Smith. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10%. That warrant will issue immediately. Court calls the case of the people versus Dean Thrush.
Good afternoon, Your Honor. Raymond Cook.
And Assistant Public Defender Nicholas Bukovich on behalf of Mr. Thrush, who is appearing via Zoom because I saw it.
Good morning, Your Honor.
Where you at?
Hey, good morning, sir. I need a camera. I don't know. Is he?
How's that? There we go.
Oh, there you are. We got you.
All right.
Thank
Hey,
All
just so
right,
you
what
know,
do
my battery's at 98%.
All right. 98. He's in the lead.
Now can we address Bond?
And his charge on his phone as well as other reasons. Thus, as people would be.
No objection from the defense.
Sir, this case is dismissed. Mr. Thrush.
Thank you so much.
Thank you.
Thank
And
you,
Mr. Thrush, I got to thank you for something. I appreciated that when you got on and you turned on your camera,
You took your hat
you
off.
removed your hat. And I appreciate that, sir.
Oh, you're welcome, sir.
All right. You take care of yourself.
Thank you. You too, sir. Have a great day.
Someone's going to come along and ruin this
Court
judge's
calls the
day.
case. People versus Daniel Worth.
Hold your breath.
Hello, Your Honor. Behalf of Mr. Worth.
Hello, Your Honor.
There you are. All right.
So this is the case of
Don't ask him how much power is it. No, never mind. Go ahead. We're good.
something by Washington. I think the people.
Yes.
Or will come up with a plan.
Gotcha. Need the you want the 2nd or the 16th?
I think the 2nd should be sufficient. I just some additional time given her position. Wanted to make sure there was not going to be any conflict with our reaching out to her about this case.
Understood.
Sir, I'm going to adjourn the matter to September 2nd, 2026, 9 a.m. or as your invite indicates. All right?
Okay, thank you, Your Honor.
Okay, you're welcome, sir.
He's not AI, I promise. He actually appeared.
Court calls case People versus Senor Guevara.
Good afternoon, Your Honor. Raymond Cook for the people.
This is an arrangement for trial, no counsel.
This one? Right here.
I don't see
your name, sir?
Samuel David Guevara.
All right.
Pro
So where you are before the court on a misdemeanor complaint that alleges that on or about February 13, 2026, the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did in a prohibited fashion use chemical agents. Do you understand the nature of that charge?
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days in jail, $100 fine plus court costs. You understand that?
What did you do? Use Windex as weed killer?
First question I have for you, sir, is do you wish to be represented by an attorney?
Chemical agents.
Pardon?
No, Your Honor.
Okay, what do you wish me to do now?
Well, I brought in my bag a bunch of proof of like all the rehabs and stuff I've been doing for the past year.
Well,
I know that might not be a thing we're doing right now.
It's not.
Correct. So what do you want me to do with this case?
Throw it out.
Okay. I'm not going to do that.
I know.
Shoot for the moon.
Are you? Well, you don't want an attorney to help you through this, sir.
I mean, I know what I did. So.
Well, I don't want you admitting anything. And anything you say can be used against you. So I'm going to ask you again. Do you want an attorney to help you get through this?
Yes.
Yes. It's up to you, but it's obvious to me, I think, that you've been trying to do certain things, I'll put it this way, to improve your life.
Yeah.
And how were you going to try to get that communicated to the prosecutor in terms of arrest?
I don't. Yeah.
Yeah, you don't know.
I don't know.
So there are people that know.
Okay.
So I'm going to ask you again. Do you want to be represented by an attorney?
Let's do it. Thank you.
Well, it's okay. Fantastic.
That was the right answer.
All right. Yeah.
Yes, Your Honor. Assistant Public Defender Nichols on behalf of Mr. Guerrero. At this time, Your Honor, as it relates to the charges, we'll be standing mute. Same thing as entering a not guilty plea.
Okay.
And waiving the rest of the formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea on his behalf. I'll adjourn the pre-trial in this matter. September 2nd, 2026, 9 a.m. as your invite indicates. I will...
Address bond. Chemical agent. Wonder what he did. May have been a drug-related one. If
Set the defendant's bond at a $10,000 personal recognizance bond. Sir, I'm going to order standard conditions, including no assaultive behavior or possession of any weapons or ammunition. You understand that, sir?
Yes, Your Honor.
There's also to be no use of any alcohol, recreational marijuana, or any illegal drug. Yeah, I can't really test for any of this.
Yes, Your Honor.
Okay, thank you. Mr. Cook?
I thought the court was about to ask a question.
Well, I was. And the, what was the substance allegedly used?
Aerosol cans, Your Honor.
Aerosol cans.
Huffing. Yeah.
All
Windex's weed
right.
killer is
Thank
safer.
you. All right. You're all set.
All right. Thank you.
Been known that without us. Court calls the case the people versus Elise Beluski.
Good afternoon, Your Honor. Raymond. Well,
All we need is one Sovset to come in here and just ruin the judge's morning.
Beluski. No response. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000, 10%. That warrant will issue immediately. Court calls the case People versus Brandon Peer.
good afternoon. Raymond Cook for the people.
Brandon Peer.
Bueller?
Yes. Mr. Peer?
Yes, Your Honor.
All right. I'll need you to turn on a camera, please.
Yes, sir. I'm sorry. There it is. There we go.
There it
Sorry.
is. We got the mirror.
State your name.
Brandon Scott here.
Sir, you are before the court on a misdemeanor complaint that alleges on or about June 28, 2026, at the location of 5738 Wesley Lane in Pittsfield Township, Washtenaw County, State of Michigan, that you did make an assault or assault and battery upon Isabel Espera Marquez. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes, please.
This is a public defender case.
Waive formal reading, stand mute.
Good afternoon, Assistant Public Defender Lauren Perning on behalf of Mr. Pierre will waive formal reading, stand mute to the charges, please.
Brendan, having waived formal reading, standing mute, court will enter a not guilty plea. You're asking for an adjournment of pretrial?
Yes, please, Your Honor.
Pretrial on this matter will be adjourned to September 2nd, 2026, 9 a.m. As to bond.
We will have no objection to a PR bond. I would ask for no contact with Isabel Marquez. I would also ask that the defendant be ordered to report to community corrections within the next 24 hours for a one-time drug and alcohol test. The report indicates that prior to this offense, the defendant, as well as the victim and some others, had been at a bar or club. The report doesn't directly state whether the defendant was under the influence of alcohol, but given that they were at the club earlier that night, I would like to have at least one test to check and make sure that the defendant is sober and remaining sober.
Mm-hmm.
I will set the defendant's bond at about $10,000 personal recognizance bond. I'm going to order standard conditions, including no assault behavior, possession of any weapons, firearms, ammunition. You understand that, sir?
Yes, Your Honor.
There is to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
Then I'm also going to order that there is to be no contact with Isabel Marquez. You understand that, sir?
Yes, Your Honor.
Is there a reason for you to go to the 5738 Wesley Lane?
Yeah, like, so not to like get into detail in the case, that's like mine and my girlfriend's residence, and
that's our
not
crib.
to get into detail, like that's the whole thing was like a big misunderstanding with a friend. But
hold on, sir. Who's your girlfriend?
So Claire Isabel doesn't live at that address, the 5738. Her address is in
my only all right.
Oh.
My only question is, so you have a reason to go to that address?
Oh, yes, sir. Yes, sir. Isabel's address is in Colonial Square, like five.
Well, okay. I don't need to know all that. You just need to answer my question.
Sorry.
Listen, don't make it mad.
People aren't asking for a no-go to that address.
Correct.
All right.
All right, thank you.
I am going to order, sir, that you report within the next 24 hours to the Department of Community Corrections for a one-time drug test. Do you understand that, sir?
Yes, Your Honor.
All right. Thank you.
Thank you, Your Honor.
Hold on a second. What?
Mr. Pierre, I put my cell phone number in the chat. Can you
is that what
me...
that was popping up? Okay.
Can you send me a text from your number to that number with your name? Otherwise, I do not have your phone number, and it's important for us to stay in communication.
No, yeah. Okay. Yeah, I'll write your number down, the 73. Okay, I got it right now.
Yep. Yeah.
All right,
just don't say it, just so.
No, yeah, I'm not.
Don't
I'll
say
text you right now. Thank you.
Court calls the case people versus Defia Terry.
Raymond Hook for the people.
Mr. Terry?
Hello, what's your name?
Sophia.
Last name?
Terry.
Ma'am, you are before the court on a 2-count misdemeanor complaint. 3-count misdemeanor complaint.
Count that alleges that on or about February 20th, 2026, at the location of 3000 Woodland Hills Drive, apartment 21 in Pittsfield Township, Washtenaw County, state of Michigan. Count one alleges that you did commit the assault and battery on an Alexis Montoya. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that charge and maximum penalty?
Yes.
Count two alleges that on that same date and at that same location that you did commit an assault and/or assault and battery upon a Haley Naud. You understand that charge?
Yes.
And the maximum penalty is the same as the other one, 93 days, $500 fine plus court cost. Count three alleges that on that same date and at that same location that you did commit the offense of assault and battery upon a Joshua Naud. You understand that charge?
Yes.
That is also a misdemeanor punishable by up to 93 days, $500 fine plus court cost. First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Are you bragging, Northwest?
Yes, Your Honor. Assistant Public Defendant Nichols Bukovich on behalf of Ms. Terry. At this time, Your Honor, as it relates to the charges, we will be standing mute and waive any additional formal readers.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned to September 2nd, 2026, 9 a.m. As to bond in this case.
That's your bond, Your Honor. As based upon my client's appearance here today, I'll be requesting a personal reconnaissance bond.
Your Honor, no objection to a PR bond. This is going to be a bit difficult of a case for bond condition. My understanding is that the named victims on this case work at the foster care home where the defendant is currently residing. I'm not sure to what extent, or was residing at the time at least. I'm not sure to what extent no contact could be ordered given that environment, and I'm not sure if a no go-to could be ordered. She still is residing there as a ward of the state.
So she has to live there by
Woodland
state order.
Hills address.
Yes.
Can't do no contact.
It's
a family court issue.
Do you normally have contact with the individuals I listed out?
No, I do not. Also, I do not reside in Washtenaw County.
Got it. So you were transferred to someplace else. Is that what happened, or
I just moved back home to Muskegon.
to where?
Muskegon, Michigan.
Okay.
If she's no longer with that facility anymore, then Your Honor would ask for the no go to as well as the contact order with them.
All right. So, young lady, let me ask you this. Do you have a need to go to the 3000 Woodland Hills address?
No.
All right. So what I'm going to do, I'll tell you in a minute. These individuals that I listed out, do you need to have any contact with them?
Not at all.
All right. So what I'm going to do is I'll set her bond at a $10,000 personal recognizance bond. Order standard conditions, including no assault to be possession of any weapons or firearms. You understand that, ma'am?
Yes.
I'm also going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes.
I'm going to order that you have no contact with Alexis Montoya, Haley Naud, or Joshua Naud. Do you understand that?
Yes.
I'm going to order also that you not go to the 3000 Woodland Hills address in Pittsfield Township. You understand that?
Yes.
That's it. Thank you. Court calls the case People versus Van Leah Winter.
People?
Matthew's suffering heat stroke.
Mayor Winter, no response. Bench warrant will issue for defendant's failure to appear, bond $5,000. Court calls the case People versus Fantasia Allen.
And Assistant Public Defender Nichols Bukovich on behalf of Ms. Allen.
Hi, Your Honor.
Hello, your name?
Fontanasia Allen.
Fontanasia Allen.
At this time, Your Honor, we'll be requesting an adjournment. She needs a little bit more time to work on her license and is going through some other concerns right now.
Going first.
September 2nd, 2020. Well, let's do September 16th, 2026, 9 a.m. All right. Keep working on that license. Understood?
All right, thank you.
Thank you.
Thank you, Your Honor.
Court calls case of the People versus Tadriel Allen.
Another Allen. Picked up off the floor.
And Assistant Public Defender Nichols Bukovich on behalf of Mr. Allen, who should be appearing via Zoom.
Oh. Got to unmute. You had it, and then you don't.
Good morning.
Good morning. State your name.
Sigario D'Angelo Allen.
Thank you. All right, what are we doing?
How many Allens are there?
Yeah, at this time, we would just be asking for an adjournment.
Trying to get his license.
Yes, Your Honor.
During the matter to September 16th, 2026, 9 a.m. Bond continued. All right. Thank you, sir.
Thank you, Your Honor.
Court calls the case of the People versus Tiana Allen.
Good morning, Assistant Public Defender, Lauren Perry on behalf of Ms. Allen.
State your name, please.
Tiana Allen.
All right. I have before me a plea form that indicates that the defendant is going to be pleading guilty to the charge of operating while intoxicated, the 93-day offense. Upon her successful plea to that, count 3, counts 1 and 2 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That's
And please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Tiana Allen.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Court could order any rehabilitative services or community service the court deems necessary. Court would also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes.
Do you understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed or had cause to be signed an advice of rights on your behalf. Is that correct?
Yes, sir.
Do you have any questions regarding any of those rights?
No, sir.
You understand you're giving up all of those rights, including the rights contained in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Has anybody threatened you or coerced you in any way?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're indeed guilty of this offense?
Yes, sir.
On the date of December 31st, 2013, at the location of, I have one on here. Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Matthew Brown put the hat on.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
He's about to
Yes,
drive.
sir.
I'm not even going to ask you if you recall how much you had or what. Did you come? Did the police stop you?
No, they walked up to the car. I was in the drive-through.
Okay. So you were at drive-through. What was that? McDonald's?
I think Steak and Shake, if I'm not.
Steak and Shake. Okay,
Yeah.
so you were at the drive-through and they walked up to your vehicle?
Yes, sir.
Did they?
They said, ma'am, this is a Wendy's.
Are you disputing the right of the police to walk up to your vehicle and to question you?
Did I dismiss? I didn't hear you. One more time,
Are you
please?
disputing that they had the right to do what they did in terms of coming to contact with you?
Yes.
You are?
Okay, let me make sure. You don't think the police should have been able to come up to you?
No, I guess they should have. I think I can't really remember. I think that one of the employees called the police.
Okay. And then the police came to you because they needed to check on you based upon that complaint, correct?
Correct.
And you're not making a legal challenge to the right of the police to do that, are you?
No.
All right. Were you ultimately arrested?
Yes, sir.
All right. Were you taken to the police station or the hospital?
Police station.
All right. Did they give you a breath test?
Yes, sir.
Do you recall what the results of that were?
They said it was
No,
minty
sir.
fresh.
It's a data match.
Data
0.19 and 0.18.
0.19, 0.18.
So your test results were 0.19 and 0.18. Do you have any reason to dispute those results?
No, sir.
Sounds about right.
All right.
Double the limit in the drive-through.
Ma'am, I do have to advise you that if between the time of my taking your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, ma'am?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
That's fine.
Court will accept the defendant's plea of guilty to count 3. The operating while intoxicated. Counts 1 and 2 are dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing will be September 9th, 2026, 9 a.m. All right. Bond will continue. All right, ma'am. I need you to hold on the line. I need you to hold on the line. We're going to put you into a breakout room with my probation department so we can get the process started, okay?
Yes, sir.
All right. Thank you.
You're welcome.
Court calls the
Matthew
case.
Brown. Oh, wait. We've got another.
The people versus
iPad.
Sequana Arian Andrews. No, I messed that up.
That's still on behalf of this.
Good afternoon, public finance marketer. Ms. Andrews, say your name, please, ma'am.
Oh, prop
Ma'am,
baby.
can you state your name?
Cornarian Andrews.
That was close. All right. What are we doing?
Yeah, so I'm requesting a little bit of a lengthier adjournment. Miss has a hearing in Detroit on the tickets that I believe are keeping her suspended for September 27th. So we should have an answer if she can obtain a valid license after that date, is my understanding.
September 27th.
Right.
Or October 7th, right?
Yes.
All right. I'll adjourn the matter to October 7th, 2026, 9 a.m. All right. Sanders, good luck with your hearings.
Thank you. I appreciate you.
All right. Take care.
You too.
Court calls case, People versus Christina Bowling.
Still on behalf of this.
Good afternoon, this is about defendant Lauren Kearney on behalf of Miss Bowling. The last hearing that was set.
That was a good call.
By the stipulation.
It's a prank
I
call.
don't
I
know
was
why
trying to
she's
bring him
not
online.
here.
He
I
hung
can't
up.
reach this in between right now.
Bench warrant.
He told me
5,000. 5,000.
He told me I'd overpaid my electric bill.
Warrant will issue immediately. Court calls case, People versus George Bowman.
On behalf of Pittsfield Township.
Good afternoon, this is about defendant Lauren Kearney on behalf of Mr. Bowman. You know, Mr. Bowman, so
you're going to move the account to a double parking to accept that admission of
Ms. Perroni, on behalf of your client, do you admit responsibility to the fact that January 26, 2026, the location of Ellsworth Road, Pittsfield Township, that they did double park a motor vehicle?
Yeah.
Court will accept that admission. 2 count 2. Count 1 is dismissed. Fines and cost of $180. When can that be paid?
2 count 2, huh?
I am requesting that the court consider reducing the fine. So Mr. is on fixed income. I think he's like 69 years old. He said that he
A young pup. Go ahead.
said that he is going through a difficult financial situation because he had to help his sons pay for their rent, so he's behind 1 month on his rent. He, like I said, is on a fixed income, can't drive, he said he can't see, he's having issues with his eyes, so he can't work. So
This is a driving offense, though, right?
I'm asking the court to consider all that when assessing a fine. Sounds pretty. He sounds like he's going through it, Mr. Bowman.
You know, Ms. Perroni, that's what makes you a good attorney, because how am I going to say no? Right? You just laid out everything in that poor guy's life that.
I told him I would. He was gonna come, and I was like, you could tell the judge all that because it's probably even better for him. But he was like, can't get here, so. So I told him I would tell him.
Matthew is getting tired of waiting.
So I'll waive $90 of that. So he needs to pay $90. Tell him I'm going to give him till December 31st, 2026. Got to the end of the year to get it done. Wow.
Antowine Brown. Looks like he's on the
First
job site.
client had the whole license thing. We were done. That took forever. Then you just did this to me. Thin ice, Perroni. Court calls the case, People versus Antoine Brown.
In assistant public defendant Nichols Buckovich on behalf of Mr. Brown, who's appearing via Zoom.
Oh, there he is. Sir, state your name.
Antoine Brown.
Yeah, and at this time, I'll be asking for an adjournment.
Adjourn the matter to September 2nd, 2026, 9 a.m. Bond continue.
Just Stephanie got a bingo. I've just verified all those are
Court calls
correct.
case people versus Matthew Brown.
Matthew, it's your turn.
Assistant Public Defendant Nichols Bukovich on behalf of Mr. Brown, who I also saw on Zoom.
Sir, state your name.
Matthew Brown.
At this time, Your Honor, I'll be requesting an adjournment. I know Mr. Brown was waiting on some information from the Secretary of State to be able to take his driver's test.
September 16th, 2026, 9 a.m.
Thank you.
Thank you, sir.
Yep.
Court calls case versus Fernandez Burris.
Good afternoon, Assistant Public Defender Attorney on behalf of Mr. Burris.
Yes.
Oh, that's you.
Where are you?
He's iPad.
I'm here.
What's your name, sir?
Fernandez Burris.
Okay. What are we doing?
Have I been
So,
gone
Your
this whole
Honor,
time?
I'm requesting an adjournment of over 30 days. Reason being, Mr. Burris, I received confirmation from his caseworker that he's in treatment at location in Toledo, Ohio. He will be there for 30 days. I did send the confirmation over to Mr. Stiller, so I'd ask again for an adjournment and that he be allowed to be out of state.
He already is. All right. Well, I will allow him to reside out of state for purposes of treatment. And then I'll adjourn this to September 16th, 2026, 9 a.m. Thank you.
Thank you.
Court calls the case people versus Devon Carlton.
And
Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Carlton. I have been reaching out. Mr. Carlton has appeared at all his prior court dates. I did reach out to him via email because I know his phone was out of service. I cannot explain his explanation, his lack of appearance here today. However, I would request adjournment based upon his previous.
It's a second phone issue. No, go ahead. I'm sorry.
Based upon his previous.
Not that I'm keeping count. Go ahead.
I would request the consideration of an adjournment based upon his previous appearances because he has regularly attended his other court dates.
Bench warrant will issue bond setting him out $5,000. I give a 10% privilege on that. Court calls the case people versus Raymond Sendek.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mrs. Sendek, who is appearing via Zoom.
There he is. Sir, state your name.
Raymond Sendek.
Thank you. What are we doing?
We'll be resolving this matter today with a mission of responsibility to a civil infraction.
That's correct. Parking. He does have a temporary instructional permit. He's updated mission and
Mr. Sendek, you admit
Yes, sir.
responsibility to the fact that on June 7th, 2026, at the location of Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, double parked a motor vehicle.
I do.
Court will accept that admission. Count one is dismissed. Fines and costs of $180. When can you get that paid, sir?
By the end of the month.
By the end of this month?
Yes, sir.
Pay it by August 31st, 2026. You're all set.
Thank you.
Thank you. Court calls case people versus Lamont Chapman.
And Assistant Public Defendant Nicholas Bukovich on behalf of Mr. Chapman.
Your name, sir?
Lamont Chapman.
Okay.
At this time, Your Honor would be requesting an adjournment. Rob had time to work on his license.
Adjourn the matter to September 16th, 2026.
Mr. Hanks is about to lose his hats.
Thank you, sir.
Thank you.
Court calls people versus Gerald Green.
People on the file indicate 49 as well.
Conrad Solar on behalf of Township in case 021.
And more hearing for all cases. Not checking.
Not
Bench
checked in.
warrant.
Bench warrant.
Why do I have this? He's got a fellow. Okay. Bench warrants will issue for defendant's failure to appear
bond in each of the cases will be set in the amount of $5,000, give a 10% privilege on that. So,
Just for clarity, he set for final settlement conference on Friday at the state misdemeanor matters. We're keeping that
is he?
all off.
Oh, he said,
Yeah, he said this Friday.
I'll leave it on the docket so that it comes in, clears the warrant.
Understood. Okay.
Be almost done with this block.
Court recalls cases of people versus Shaylin Nichols.
Good afternoon again, Your Honor. Raymond Cook for the people.
Assistant Public Defender Nick Buckridge on behalf of Ms. Nichols, who is appearing via Zoom.
Shaylin Nichols.
Hello. Yes. Yeah. Oh, she be crying. Yes.
Okay, I need a camera, please.
Okay.
All right.
At this time, Your Honor,
Is that a SpongeBob shirt?
I'll be requesting to set the.
And they're done. And they're done. All right, let's jump over here. Still haven't seen anything from the court. It's been 54 minutes on the clock. Let's see here.
Excuse me.
Bless you.
Okay, folks, I'm Judge Hamilton with the Amarillo
Judge.
Municipal Court. You're here on a revocation docket. What
And
that
show
means
cause.
is sometime in the past you signed up for deferred disposition. When you signed up for deferred disposition, you had to meet certain requirements. One was that you had to pay your citation in full at the time you entered that plea of no contest. You also had to not break the law during the term of your deferral. You also, some of you may have been required to take the driver safety course or some other type of special course. And you had to submit that proof that you completed it by the time that we told you had to get it turned in. If you're on a no insurance deferred, you had to keep insurance the whole time without any lapses in the insurance. If you did not submit proof of insurance to me, well, I would not know if you had the insurance because you did not submit it to me. So make sure you submitted whatever I needed to see so that we could get these cases dismissed. I had 24 names on the docket, and I've got a pretty good showing, but there are a bunch of folks that didn't show up today.
Bench
I'm going to
warrant.
review all those people's cases after this docket is over, and I will enter judgments against them at the end of the document if their case qualifies for a judgment. Otherwise, if their case qualifies for dismissal, I will do that, and I will do the same for you if your case qualifies for your case to be dismissed.
So if you paid
I'm
your
going to
warrant,
start
you
with
don't have to show up.
Alexandria
Paid your
Trevino.
fines.
If you will unmute yourself, Ms. Trevino.
Yes, ma'am. Can you hear me okay?
I can. Looks like I've got you on a computer and on the phone, so I don't know. It's complicated, but it's okay. Hey,
Yes,
I am missing your proof of insurance for about 5 months. Did you
Okay.
keep your insurance the full time?
So yes, I submitted to your deputy court clerk, Heath Newkirk, my insurance. I guess that your court determined upon verification through a call that I did not have insurance. They called my previous insurance carrier, Progressive. I did have insurance. The following day, I forwarded him the binder. I only canceled my insurance because it was more expensive with Progressive. And so I went to the general.
Not a sponsor.
I had continuous coverage.
Did you send, and you sent me the general?
Yes, I sent it to Heath Newkirk on June 30th. And he said he would get it to you.
Yeah, let me
just
double
wanted-
check. Let me double check what I've got in the file.
We might not stick around to this one if it's all just... We might go to Minecraft court is what we might do. Have we been there in a while? No? Let's see what they're talking about today. There we go. Let's go here.
Good afternoon, Your Honor. We are hearing case 26 CR 508
State of Ohio versus Christopher P. Snavely, present in court, is the defendant, who is accompanied by his attorney, Mr. William Watson. We are here today for a hearing on a motion for intervention in lieu of conviction that was filed by the defendant on June 19th, 2026. As a result of that motion, this matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation report. The state has had an opportunity to review that report, as well as the evaluation that was conducted by Lake Geauga, and is ready to proceed. Thank you.
Mr. Watson.
Thank you, Your Honor. May it please the court. My client understands that he will be entering a change of plea on the above case. I've discussed this matter with my client. He understands to be waiving certain constitutional rights. No threats or promises have been made in order for him to do so, Your Honor. And then we would like to respectfully be heard on the intervention in lieu of conviction motion, Your Honor.
Go ahead right now on that.
All right, thank you, Your Honor. May it please the court. Mr. Snavely does not have a prior felony record. I believe there might be some misdemeanors. But he doesn't. But what he does have is a very serious drug problem. This has been ongoing for quite a while. For whatever reason, Your Honor, he's been able to fly under the radar up until now. That being said, Your Honor, after he got caught when we were last here in court, and I had a chance to speak with Mr. Snavely, I mean, he made it clear to me that he doesn't want a felony record. This is he knows it's going to ruin his life, and he also knows with this continued drug use, he's either going to end up in prison or dead. And I think this has been a real wake-up call for him. I think it's been a real motivator for him to A, sober up, and B, get his life together. I'm hoping the court will take those factors into consideration and allow him into the intervention in lieu of conviction program. I do think that Mr. Snavely is going to be successful if the court grants it. Thank you, Your Honor.
Ms. Himmelane, as to the motion.
Your Honor, the state has no objection to the motion.
All right, I'll grant the motion for intervention. Mr. Snavely, how old are you?
30.
How far did you go through school?
I completed 11th grade and part of 12th.
Are you a U.S. citizen?
Yes, sir.
Who's got the paperwork? Bill, you got it?
I have it.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Just what I'm prescribed.
What are you prescribed?
Suboxone.
When did you take it?
This morning.
Well, that could be a problem.
Does that affect your ability to understand what's going on here?
No, sir.
Then we're good.
All right, did you get a copy of the indictment in this case?
Yes, sir.
Any questions about it?
No, sir.
And you're pleading guilty to these 3 charges, is that correct?
Yes, sir.
All right, before I accept your guilty plea, I need to determine that you know and understand constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Watson some more, let me know, and I'll give you more time. You understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to these charges?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yep.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In count one, possession of heroin. It's a felony of the fourth degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes, sir.
In count two, aggravated possession of drugs, it's a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
Count 3 is aggravated possession of drugs, felony 5, 12-month maximum prison sentence, and a $2,500 maximum fine. Do you understand that?
Yes, sir.
I could give you a consecutive sentence. That means one sentence after another for the separate offenses. If I did that, the maximum prison sentence would be 42 years, 42 months, and the maximum fine, $10,000. Do you understand that?
Yes, sir.
If you are convicted of these offenses, you understand there may be a driver's license suspension of between 6 months and 5 years.
Yes, sir.
If you are convicted, then your felony conviction would prevent you from owning or possessing a
Very
firearm.
soothing voice.
You understand that?
Yes, sir.
Do you understand that if a prison term were to be imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violated any terms and conditions, then I could send you to prison for 42 months. Do you understand that?
Yes, sir.
All right. Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
If you get convicted in this case, did anybody promise you what I would sentence you to?
No, sir.
Do you understand I would not have to follow the sentencing recommendation of either the...
All of the suspected narcotics were sent to the Lake County Crime Lab for testing, and the crime lab confirmed that the glass smoking pipe tested positive for less than 0.06 grams of methamphetamine, a Schedule II controlled substance. The plastic bag with tan solid substance and powder contained 3.38 grams of heroin, a Schedule II controlled substance, and the pieces of clear crystalline solid substance was 1.17 grams of methamphetamine, a Schedule II controlled substance. Thank you.
Thank you. Mr. Watson, anything to add to those facts?
No, Your Honor.
All right, Mr. Snavely, did you hear what Ms. Himmeline said the facts would show if this case went to a trial?
Yes, sir.
Are those facts true?
Yes, sir.
All right, what is your plea to count 1, possession of heroin, a felony 4?
Guilty.
What is your plea to count 2, aggravated possession of drugs, a felony 5?
Guilty.
What is your plea to count 3, aggravated possession of drugs, a felony 5?
Guilty.
Mr. Watson.
And they're done just like that. Man, everyone's just abruptly ending court. Thurston County's on a break. Still nothing from John Stevens. They've deliberated for an hour now. Hour and 7 minutes. Courtrooms are quiet across the country right now. So we've got one more.
Divorce with my wife and what she's doing.
Okay, I appreciate the divorce. My question is, how long have you been without much income?
A year.
Is this family court?
Are you a veteran?
I am not.
Okay. I do find after he completes a financial disclosure form, I will go ahead and appoint the public defender's office to represent him.
Not family court.
In these cases. Now, if you choose to retain an attorney, Mr. Schaaf, you certainly have that right, and the attorney can substitute for the public defender. But if you fail to do so or you don't do that, you will have a public defender to represent you in these cases. Okay, now I'm going to address the issue of bond. Of course, this bond recommendation from the prosecutor was submitted before a warrant was issued. This was submitted back on May 19th, asking that bond be set in the amount of $10,000 personal recognizance. The allegations are that on February 20th, 2026, the defendant possessed 0.33 gram of methamphetamine.
I'll meth you up.
Mr. Schaaf, are you on probation with any court?
No, sir.
About to be.
So you were convicted of domestic violence in April of 2024 in Western County Court?
No, sir. It was a plea taken that I regret to this day, and it was a misdemeanor.
Right, but my point, my comment is, whatever conviction you have, you're not on probation with that court?
No, I'm not, sir. That's all behind me. Part of the divorce and what my wife has caused in my life, ex-wife.
Tell us how you really feel.
Is this divorce final?
No, I think it's next, in a month or so, there's another last meeting.
Where do you live, Mr. Schaaf?
Painesville.
123 Sesame Street.
839.
123 Sesame Street.
SUN.
What's the zip code?
8675309. No, that's not something else.
Is that where your parents live? You mentioned something about your parents.
That's correct.
The address on the complaints are 188 Burroughs.
Come on.
Here we go.
Were you aware of these charges?
I was not.
And where and how were you arrested?
I just was in Ashtabula last night and got arrested.
Okay.
Surprised the daylight's out.
Are any criminal charges, as far as you're aware, going to be filed as a result of what happened during your arrest?
No.
Okay.
That I know of.
This is Bird's Eye Court. Is there someone underneath me? No, he's on Zoom.
Well, your criminal history isn't the greatest, Mr. Schaaf. I guess the question is whether you represent a flight risk to me or not. And the question is whether if I give you a personal recognizance bond, whether you're going to show up for court when you're supposed to.
Hello. It's all from my wife, sir. All that stuff was caused from what she was going through and doing to me, that I finally got out of all that.
Mm-hmm.
Apparently the ex-wife is
Okay, on the felony case 26 CRA 159,
allegedly.
Bond will be set in the amount of $10,000 personal recognizance. I am ordering a urine drug screen on Mr. Schaaf before he is released. He must submit to a urine drug screen. If he fails to do so, he won't be released. He is ordered as a condition of his bond that he is not to consume or possess alcohol or drugs. He is subject to random chemical testing by probation and law enforcement. Mr. Schaefer, are you currently receiving the treatment services of any substance abuse or mental health agency?
No, sir.
Have you ever?
Yes.
Where was that?
I went to Glen Bay in 2010.
That's the last time?
Yeah.
Okay, well, I'm ordering that you undergo an alcohol drug assessment at Glen Bay. You're ordered to go back to Glen Bay for an assessment and to successfully comply with any and all recommended course of treatment. These are all conditions of your bond. In case number 26 CRB 160, bond will be set in the amount of $5,000 personal recognizance with the exact same conditions: urine drug screen before being released, no, not to consume or possess alcohol or drugs, subject to random chemical testing, an alcohol drug assessment at Glen Bay, and successfully comply with any and all recommended course of treatment. These cases will be set for a preliminary hearing and pretrial conference in the very near future. Okay, Mr. Schaefer, here's the way it works. In my court, you're being released on your own recognizance. We're going to give you a hearing date for your preliminary hearing and pretrial conference. Before you're released, you will know when you have to come back to Conneaut City Hall in our court before you're released. If you fail to come to court when you're supposed to, or if you fail to stay drug and alcohol free, if you fail to provide a urine drug screen, or if you fail to follow through with the assessment at Glen Bay and their recommended course of treatment, I will revoke your bond. I'll issue a warrant for your arrest, and then I could order you to pay $15,000 to the state of Ohio. Do you understand all of the consequences you face if found to have violated any of the conditions of your bond?
Yes, sir.
Do you have any questions for me?
I do not, sir.
Okay, thank you very much. This matter is concluded then. Thank you, officer.
You're welcome.
All right. And we're done. The bird's eye view court is finished. We're going to do probably a break. I'm looking, Judge Simpson might be back here in just a second. Waiting for his court. But probably going to go to break while we go on verdict watch. Wait for Judge Stevens. As soon as we go to lunch, I'm sure they're going to come back. So the idea is we're going to tell them we're going to lunch. And if they come back with the verdict immediately, then we're going to jump immediately. Mass shooting NC. What? Oh, I'm in NC. Where are we at? What's happening? I can tell you I didn't hear anything. Coswell County. I don't even know where that is. We've got 100 counties in this state. Let's see what's happening here. It's right next to Virginia. It's north of Greensboro and Durham, so west of the Triangle. Sort of south between Greens. It's on the well. Never mind. This is right where they had the manhunt the other day. I think. Pretty sure. Just south of Danville in Virginia. Let's check and see what's happening. Got the scanner up with its crickets. They don't have great scanner traffic from these parts of the state. Let's do a quick search on this one. Update from officials. It's a public safety event reported around 8:30 a.m. Last article published. Let's see. Verification is continuing. Mass shooting reported. There's no threat to the general community of Prospect Hill or Caswell County. Deputies are responding to the scene alongside North Carolina State Highway Patrol. Multiple people were shot Wednesday morning at a residence. There's going to be a press release later today. No confirmed injuries or deaths were stated in the available reporting. Who's this? I don't know who that is. When it's in a residence, it's probably not. It's probably domestic, is sadly the case. Happened starting at 8:30 a.m., so we've got a handful of hours between us, about 5 hours ago. If it's crickets right now, there's probably no manhunt going on, which means the shooter's probably either in custody or permanently out of custody for everyone. SBI is assisting. Let's see if we can get an update from SBI and CSBI. The SBI is under a storm, a poop storm of bad press when the director showed up, like standing side by side by somebody they were supposed to be investigating, allegedly. They say it wasn't as it seems and everything's fine. They haven't tweeted anything since yesterday from the SBI, so I don't think there's anything big. Amber sent me a clip. Let me look. Candy thief. Not hearing it.
And ate the candy out of his candy bowl on his counter. He said someone jimmied his lock sometime last night between 2:30 and 3 a.m. and ate the candy out of his candy bowl on his counter. And he'd like to speak to an officer.
Somebody had the munchies and they got forgetful, I think. All right, we're going to go to break while we wait for the judge to come back from court. If any of you see Judge John Stephen Jr.'s personal meeting room come back online for Jefferson County Criminal District 5808, do let us know, and we'll go live with it, because we think we will have a verdict here in mere moments. So break means Ari wants lunch. Yes, I think there's actually a command you can use when we go on break now. It should be working. It's not the lunch one. It's just break. So you can give that a try. I think I got it working properly. Although I need to put another sound effect so it has like two different ones that it rotates through. We'll be working on that as well. I'm not seeing anything. There it is. Is it working? Doesn't seem to be working very well. Oh, I have to refresh. Try it again.
When are we going to break for lunch, Judge?
There's the lunch one.
Take a short break.
Taking a sharp break. All right, that's all. All right, let's go to lunch. We're going to keep an eye on the court so we can get a
Remember
verdict.
in the beginning when we started 110 years ago?
I'm showing an hour and 22 minutes, 37 seconds on the verdict deliberation clock. What is free hat? What is free hat? Oh, man. All right, I need to turn XP up a little bit.
We're
It's too quiet. XP, there we go. Edit this one. Audio. There we go. Done. Click save. Okay, try the hat one, or try XP again. That should be better. Try to crank it up. All right, if you see something on the Judge Stevens side, do let me know, and we'll be live shortly. Other than that, we do have a portal set up. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. Portal's already up. Let's see, let's go back here, make sure the portal's in place so you can make the jump. It shows an hour, might be less than that. Just depends what the verdict thing is. General channel permissions, that's not it. Discard changes. Redirect. There we go. All right. Have a great lunch. We'll see you guys in just a little bit.